We're recording.
Thank you. Good morning, everybody. We're here for our meeting up for the Council on Access and Fairness. Shannon, could you please read our housekeeping reminders?
Yes. Welcome committee members, liaisons, and members of the public to the Council on Access and Fairness meeting. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference. Per Bagley-Keene requirements, all cameras must be kept on for the duration of the meeting. If you are unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of your surroundings behind you. All committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select Live Transcript at the bottom of your Zoom screen, then select Enable Auto Transcription. Thank you.
Thank you, Shannon, and welcome everyone, committee members, our representatives and members of the public. Elizabeth, will you start us off by taking roll, please?
Yes. Yemi Adebomineri, Komal Chakshi,
Present.
Tara Davis.
She
stepped out. Okay. She just stepped out. Cecilia De Leon,
Present.
Jazreel Hill,
Present.
Tristan Higgins,
Present.
Angelica Salceda,
Thank you.
Yusuf Zakir, Shalak Guinness,
Present.
Judge Michael Rhodes.
Present.
We have a quorum, and I also wanted to acknowledge that we have Judge Diaz and Alana Matthews as our liaisons, and then Trustee Buenaventura is also present.
Good morning.
Good morning. Thank you all for being here in person or on Zoom. We're going to take some items out of order today in order to accommodate some scheduling issues. That includes our public comment portion. We anticipate that we're going to start the public comment portion at about 10:45. We appreciate your patience and understanding. What I don't see is George here yet.
Shannon, is George in the attendee pool?
Yes, he is. One moment.
Thank you.
All right, so we're going to start with item 4.1. It's a presentation and discussion on Rule of Professional Conduct 8.3 and Rule of Professional Conduct Rule 8.4.1 from Chief Trial Counsel George Cardona, who is joining us on Zoom. Thank you for being here this morning.
Oh, thank you, and thank you for taking this out of order. I have, unfortunately, another meeting that I have to get to, so I'll just get right into it if it's okay. I'm going to share my screen and pop up a PowerPoint. All right, so can somebody give me a thumbs up if they can see that? Okay.
I can see it.
Perfect. Okay, so first I'll apologize for some typos in what was circulated prior to the meeting. It is June 27th, 2025, not June 27th, 2024. So I'll just go into it. So we're going to cover today first, some data on Rule 8.4.1, which we've updated to now cover the period from the time when the rule went into effect, which was November of 2018 through May of 2025. And thanks to the Office of Research and Statistics for pulling all the data. So you'll recall that Rule 8.41 basically has 6 different potential violations or 6 different allegations. 2 of those under Section A relate to basically unlawful harassment or discrimination on the basis of a protected characteristic in representing or terminating or refusing to represent a client. So these first 2 categories, A1 and 2, relate to representation of a client. And then another set of allegations that relate to law firm operations, which include unlawful discrimination, unlawful harassment, unlawfully refusing to hire or employ based on a protected characteristic, or unlawfully retaliating. So this is what we've looked at, and as in past times, we've given you data on the numbers of allegations that we've gotten over this time period. So simply the number of allegations, and a particular attorney might be subject to multiple allegations, either in a single complaint or in multiple complaints. This is just looking at the total number of allegations over that time period so that we get a sense of how many have been closed in intake, how many have been closed after investigation, that is, they've made it through intake and been referred for investigation, how many have been the subject of a non-disciplinary resolution, such as a warning letter, how many have actually resulted in discipline, and how many remain open. So you can see those percentages here. Then we broke it down by allegation over time so that you have the same breakdown, but this time by individual allegation. So you can see here that by far the largest number of allegations that we've received are under A1, which is unlawful discrimination or harassment in the course of representing a client. And again, you can see that breakdown here. We then looked at it by year, looking at the number of allegations that came in each year. As you can see from 2018, when the rule was first adopted, there was a gradual increase in allegations through 2022, and then there has been a gradual decrease, although remember that for 2025, this is just January through May, so that's the first 5 months. So if we were to project that out, we would be somewhere right around 200 at the end of the year, if in fact that pattern holds true. But this is the pattern over time in terms of allegations. Given you the 2 cases that were publicly filed discipline, where we can disclose the details. So one was a case against Attorney Christopher Hook. It was originally opened as an 8.41A1, that is, unlawful discrimination or harassment in the course of representing a client. Ultimately, a stipulation was entered into to a violation of Rule 8.4D, conduct prejudicial to the administration of justice. And based on the presence of a number of mitigating circumstances, the actual discipline imposed was a public reproval. This involved a series of harassing emails to opposing counsel, making threats and using homophobic epithets. And then I've given you a quote from the stipulation that justified the violation of 8.4D based on that conduct occurring during settlement negotiations and affecting how those settlement discussions proceeded, which was an impact on the administration of justice. So that's the Hook case. The second case that we filed was a case against Attorney Timothy Allen Scott. This one came in the same way and ultimately was settled the same way with a stipulation to a violation of Rule 8.4D. Again, there were a significant number of mitigating circumstances, and so it was a public reproval. This was a case where, on the record, during a proceeding, the attorney used a derogatory epithet, "See you next Tuesday," toward female opposing counsel during a judicial proceeding. Did this deliberately, thinking that the court would not understand what it meant. The court, in fact, did not understand what it meant. There were a number of hearings back and forth before the court ultimately expressed their displeasure with this conduct and referred it to the state bar for disciplinary proceedings. And again, the impact, the interference with the proper functioning of the judicial system justified the 8.4D charge. So then, having looked at allegations, we're going to move to looking at individual attorneys. And so this is the same pie chart for individual attorneys, showing the number of attorneys against whom there was at least one allegation during this time period under 8.4.1, and what happened to the individual attorney. So again, you can see the breakdown. It's a very similar breakdown. The majority of cases are closed in intake, smaller majority closed in investigation, and then smaller in the additional categories. The pattern over time is roughly the same, which is what we would expect. So you can see the same kind of shape of the curve of attorneys who are subject to 8.4.1 allegations over time. Then we started looking at the demographics of the attorneys who were the subject of an 8.4.1 allegation. So this is looking at the total of the attorneys who received one or more 8.4.1 allegations during this time period, and looking at the demographics of that group as compared to the active attorney population as of May 2025. So for here, for example, the 30.93% of attorneys who received an 8.4.1 allegation were female, whereas in the active population of attorneys as of May 2025, 43.17% of attorneys are female. So this gives us a comparison that we can look at. And so this shows the comparison. So you can see, for example, that the representation of females in the set of attorneys who received 8.4.1 allegations is less than their representation in the active population, whereas for males, it's the reverse. So that's the information on gender. Then we looked at race and ethnicity, and this is the same comparison. The orange is the percentage of the active population. The blue is the percentage within the population of attorneys who received one or more 8.4.1 allegations during this time period. And so you can see again that white attorneys are more represented in the population of attorneys who received 8.41 allegations than they are in the active population. Whereas, for example, Asian American attorneys down at the bottom are less represented in the population of attorneys who received an 8.41 allegation than in the general population of active attorneys. And so this gives the breakdown in that way. We then looked at firm size as well to see, again, the comparison. And so again, here you can see that solo practitioners, firm size of 1, are more represented in the population of attorneys who received one or more 8.4.1 allegations than they are in the active population. Whereas, for example, at the other end, attorneys in firms of 200 or more are less represented in the population of attorneys who received 8.4.1 allegations than they are in the general active population. Then we looked at the sector of employment using a set of standards that the Office of Research and Statistics uses for looking at statistics, and did a similar comparison. So again, you can see here that those who are in a firm of 2 or more are more represented in the population of attorneys who received one or more 8.4.1 allegations than they are, less represented than they are in the active population. Government and public attorneys are more represented in the 8.4.1 population than they are in the active population. Then we did a breakdown of years in practice. We didn't have the comparison here, but this is just what the attorneys' years in practice were who received 8.4.1 allegations. So you can see that the largest percentages are in the vast bulk of 8.41.1 allegations occur against attorneys who have 5 to 39 years experience. So that's the data that we have on 8.4.1. I'll turn then to 8.3. So this is a different time period because that rule went into effect in August of 2023. So here we're looking at the time period from August of 2023 to May of 2025. And I apologize, but on the slides that were circulated to you, the various charts were labeled as being from 11/2018 through 5/25. I've changed that in what I'm showing. It's actually from August of 2023 through May of 2025, which is what's now shown. And I'll recirculate the PDF to Sharon so she can distribute the corrected one. But again, this is looking at comparing the attorneys who were 8.3 respondents. That is, they were the subject of a complaint that was submitted pursuant to Rule 8.3 sometime during this period. That's the blue column, as opposed to the active attorney population as of May 2025, which is the orange column. So you can see here, for example, that females are less represented in the population of attorneys who were the subject of an 8.3 complaint than they are in the active population, whereas for males, it's the reverse. We then looked at race and ethnicity, and same comparison. Here, most of them appear to be fairly close in terms of their respective populating of the two different populations. Then we looked at firm size, and we see a kind of similar pattern. Solo attorneys are overrepresented in the population of attorneys who received 8.3 complaints, whereas attorneys in firms of 200 or more are less represented than they are in the active population. Then we looked at sector and saw patterns similar to 8.4.1, although here firms of 2 or more and solo attorneys significantly more highly represented in the population of attorneys who received 8.3 complaints than in the active population, whereas government public attorneys and corporate in-house attorneys are significantly lower. And finally, we looked at practice area here as well to see what was showing. So this is for the top 8 practice areas for Rule 8.3 respondents. So these are the practice areas that had the highest numbers of attorneys who had received 8.3 complaints sometime during this period. And we identified the top 8 and then can show you the demographic comparison for attorneys within that group, comparing their representation in the population of attorneys who received an 8.3 complaint as compared to their representation in the active attorney population. So again, you can see that attorneys who are in these top 8, since we selected the top 8, you can see that for each of them, they are more represented in the 8.3 population than they are in the active attorney population. And I believe that's the data that we had and could pull on these. So with that, I will turn to see if there are any questions. And if it's okay, I'll go ahead and take down the slides. I can always put them back up, but that way we'll all be able to see each other.
Any questions from any of our committee members? I have a question. In terms of the 8.3, I know it's we're not yet at the 2-year mark. What were the rough numbers in terms of total number of complaints filed under 8.3? And were there any that were resolved by discipline?
So we had a total of 798 attorneys were the subject of a complaint submitted pursuant to Rule 8.3 over this time period. I don't have the data on how many of those actually resulted in public discipline, but I can see if I can get that.
Thank you. Anybody else?
Do we have or can we get the data, particularly for 8.3, as to whether the complaint was brought by a member of the public versus another attorney? Does that make sense?
So a Rule 8.3 complaint, in other words, we characterize a complaint as a Rule 8.3 complaint if it's one submitted by an attorney pursuant to their duty under Rule 8.3. So that's how we're characterizing. So that's the 798 number.
Okay, thank you. Sorry for not understanding that.
Oh, no, that's my fault.
I have a question. Apologies if I missed this. So this data is for the number of individuals who were reported pursuant to 8.3, but in tandem with violation of another rule. Is that correct?
So this would be where the complaint, where we have information indicating that the complaint itself, regardless of what the allegations in the complaint were. But so the Rule 8.3 complaint was submitted pursuant to Rule 8.3. In other words, it was an attorney providing that complaint pursuant to what they believed was their obligation under Rule 8.3. It could have alleged any one of a number of disciplinary violations. Does that answer?
Yes, thank you.
As you might suspect, George, there's a follow-up question, at least for me, on whether there's a breakdown about what those complaints allege. But I understand you have limited data at this point.
Yeah, I mean, if there's an interest in that, I can see if we can, I can see what we can track down on that. So in other words, there's an interest in what the allegations were in the 8.3 complaints, at least on some kind of statistical basis.
Yes, I'm seeing nodding.
Okay. I will see what we can pull on that.
I appreciate that. I know you come here with information and statistics every time, and we always ask for more information and statistics, but it is very helpful, at least for me, speaking for myself, to get a better picture of what's going on. So thank you for.
No, that's fine. That's why I come. You know, as you can see, we've added some stuff in response to prior questions, so we'll keep adding.
Any other questions for George while he's here? Okay, I don't see any other questions. Thank you so much for coming and being our first presenter today. And we'll let you get to your other obligations.
No problem. And again, thank you for taking me out of order.
Thank you. Okay, at this point, we'll move to the public comment portion of today's meeting. Are there any members of the public who wish to comment about any item on the agenda? We'll set the time for public comment for 3 minutes. Shannon, are there any members of the public in the waiting room with their hand raised?
No, there's no one with their hand raised.
All right. We did not receive any public comments in advance of the meeting either. We're going to move now in order for the time being to item 1.1. It's the chair's report. That's my report. And I'll just briefly say that yesterday we had a wonderful summit on civility and bias here in Los Angeles with about 40 folks attending. I'm not going to go into too much detail because we're going to get an update from Danielle McRae about some of the details on that, but it was, at least for me, a very inspiring event to hear from a lot of different folks, including some law students and undergraduate students who are invested in building a better future for the state bar, for attorneys, for practitioners, and for the next generation of leaders. Which was really exciting for me to see. I also have the opportunity now to thank some folks who are on COAF, including a departing member. Unfortunately, this will be Jezreel's last meeting, and we have a certificate of recognition from the Board of Trustees and from Leah Wilson, our Executive Director, thanking you for all that you've done. And we wish you nothing but the best and best of luck as you move on to bigger and better things, but we will miss you here. And I'm going to come over and give this to you now.
I'll miss you all. I'm glad I could see you one last time in person. For those who don't know, I'm relocating to Virginia to be closer to family. So thank you for having me during this time. It's really been a pleasure working with you all and a privilege to be a part of this work. And I hope to continue in this spirit with the Virginia State Bar.
Well, Virginia's gain is California's loss, but we hope that we know you will keep doing the hard work. So thank you.
Thank you.
I'm also pleased to announce that we have our new leadership team for the next year. This is my second to last meeting. Next meeting in September will be my last meeting. And then I will be handing over things to Shalak, our incoming chair, and to Tara, our incoming vice chair, who I know will ably lead us forward. I'm very excited to hopefully continue to drop in on meetings and see all the wonderful things that you are going to be doing. And we'll also be welcoming our new members of COAF at our September meeting, just to watch things, and then they'll take over, or they'll come in on for the December meeting after that. So that's the chair's report. We're now going to move to item 2.1, which is our director's report from Elizabeth.
Thank you. So I just have a couple things to update you all on. First, we are working with the Legal Services Trust Fund Commission on the Legal Aid Leaders Fellowship Program. So thank you to Kamal and Judge Michael for your participation on that working group. I know that it is a very big time commitment to review all of those applications, but it is very exciting to be able to fund I believe this summer it's upwards of 70 law students at legal aid organizations throughout the state.
That's awesome.
And so we really believe that this will be a good pipeline into legal aid and a really big opportunity for these students. So thank you for that. We'll have more updates as the review process and the awards are finalized later this fall. And then my other update is that, as many of you know, all sub-entities at the State Bar that are undergo a 5-year review process. And so COAF and some other sub-entities participated in that process recently. And so the board has, approved COAF's work and as a sub-entity moving forward. And so we'll go through that process again in another 5 years. I think the only comment is that the work, remain within available resources. And then typically COAF's work plan is approved by the board. It was the agenda item for this COAF work plan for this year was withdrawn from the May board meetings agenda. But because it was attached to another item that was withdrawn. So I don't believe there's any issue with the COAF work plan itself. As you all know, we are continuing to do the work on the work plan, but it will be hopefully approved at the next board meeting. So,
Thank you, Elizabeth. We'll move to item 3.1, which is the review and approval of our March 21st, 2025 open session minutes. These were distributed, the minutes were distributed with the agenda for today's meeting. Is there any comment or discussion on the minutes? Seeing none, is there a motion to approve?
So moved.
Shalak moves. Is there a second?
A second.
Thank you very much. Tristan seconds. Elizabeth, take roll, please.
Yep. Yemi? Kamal?
Approved.
Tara?
Approved.
Cecilia?
Approved.
Jezreel?
Approved.
Tristan?
Approved.
Angelica? Yusuf? Shalak?
Approved.
Judge Michael?
Yes.
Motion carries.
Thank you. The minutes are approved. We've covered item 4.1. We'll move to 4.2, which is the presentation and discussion on the follow-up study of racial disparities in the attorney discipline system. Looks like Shannon is letting in our speakers now. Great.
All right, good morning, everyone. I think there's one more person. Kevin Way should be promoted as well. He's presenting as well. All right, there he is. All right, good morning, everyone. We're very excited. My colleagues and I are very excited to share a little bit more about several projects related to the attorney discipline system that the State Bar has done. And with that, I'll jump right in. So let me share my screen. Okay, can everyone see my screen?
Yes.
All right, awesome. All right, so I think it's really helpful to start off with some background. So in 2019, Professor George Farkas used data from about 116,000 attorneys who were admitted to the State Bar between 1990 and 2009 to explore disciplinary disciplinary outcomes that occurred between 1990 and 2018. You'll commonly hear this referred to as the Farkas study. And what this study found was that compared with white male attorneys, both Black and Latino male attorneys had a higher average number of complaints, as well as a higher rate of both probation and disbarment. And the study tried to look at some of these contributing factors to the disparities I just mentioned. And so it found that the number of complaints, whether an attorney was represented by counsel and prior discipline history played a role in those disparities. And it also found that Black male attorneys were subject to the highest average number of complaints and had nearly twice as many bank reportable actions compared to their white male counterparts. And so in response to the findings of the 2019 Farkas study, the State Bar in 2020 enacted 2 policies, with the first being that the State Bar began sending respondents notices about the importance of having counsel representation during the discipline process, and then also providing information about how to go about finding that representation as well. And then secondly, the State Bar began archiving older complaints, essentially making them invisible during the complaint review process when eligible attorneys were being assessed or investigated for new complaints. All right, and so for today's presentation, we'll kind of cover 4 key areas. We'll go into greater detail into each one of these areas, but just to give us a frame for the conversation today. So first is the update of the 2019 Farkas study. So essentially using the exact same methodology and just giving a 2024 update and just shifting that original 30-year window of discipline outcomes forward by 5 years, offering a more recent perspective. And the second key area is looking at more recent trends in disparities. So a brand new analysis related to the 2019 study, but kind of looking at the problem from a different angle and looking at discipline outcomes grouped by 5-year blocks all the way up until 2023. The third area being firm size and practice sector analysis. So essentially comparing investigation rates by attorney firm size, as well as the sector that an attorney worked in. And this was in alignment with the State Bar's strategic operational plan that was meant to explore other potential areas of disparities within discipline outcomes. And then finally, we looked at counsel representation and the archiving policy, as I mentioned on the previous slide. So basically an analysis of the changes in the representation rates for attorneys and racial disparities, basically looking at visible complaints and investigation rates related to those policies that I mentioned. And so also just to give some key findings at the start, we'll go into more detail into all of these. But for the update of the 2019 Farkas study, results showed that disparities did persist, but they did narrow for Black attorneys. So we saw that Black men's probation and disbarment rates declined more sharply than white men's, which narrowed the gap. And then these disparities were also further reduced once we accounted for other factors such as years since an attorney was admitted to the State Bar, as well as the different offense types. The second thing that we saw was a slight uptick in Latino disparities, but this uptick likely reflects changes in race reporting and not an actual uptick in these disparities. And I'll describe this in a little bit more detail, but essentially in the original studies, attorneys could only identify as a certain number of races. And then a couple of years later, the State Bar got a little bit more inclusive in their racial identity categories. And so people who identified as one race subsequently shift to another race. So essentially meaning that on paper, this uptick didn't actually occur. And then also we found that this update of the 2019 study using that 30-year window and then shifting it forward by 5 years, it retained 60% of the same attorneys. And so there was overlap in the attorneys who were analyzed in the original study and this update. And so this overlap may have kind of diluted the effect of the recent trends in discipline and may not reflect the current practices in discipline, which was addressed by the second, the recent trends in disparity analysis. And so what we saw here is that the Black-white probation gap, once about 3.5%, and the Latino white gap, which is around 3%, have both dropped to nearly 0. And then when we think about disbarment, the Black and white gap also has shrunk from about 2.5% to nearly 0, while Latino attorneys now show a slightly lower rate of disbarment when compared to their white counterparts. And so what we saw here is that also focusing on the 5-year blocks of discipline instead of looking at that 30-year time window like we did in the original study provided a more clearer picture of discipline outcomes and how they've changed over time. And then when it comes to firm size and sector, we saw that solo practitioners had the highest investigation rates. So this means when we say investigation rate, this means that complaints that actually move to investigation, whereas government or public sector practitioners had the lowest investigation rates. And we also saw that as firm size grew, complaint investigation rates generally dropped. So for solo practitioners, it was around 41%, and then it decreased down to 17% for attorneys who worked in firms with 200 or more attorneys. In terms of council representation, we saw that representation rates overall have risen, but they've increased less for Black and Latino attorneys. And so the at-risk policy that was introduced had little impact on council representation rates. But we did still see that having counsel generally does reduce both the risk of experiencing discipline as well as the severity of that risk as well. And then finally, we looked at the archiving policy. We saw that disparities in the number of visible prior complaints has been reduced, but there was still a greater percentage of both Black and Latino male attorneys with 10 or more visible prior complaints than white men, and Black men remained more likely to be investigated, even after controlling for the number of non-archive complaints as well. All right, so first getting into more detail about the update of the 2019 FARCA study. And so as I mentioned, this 2024 update just shifted the original study's 30-year time frame forward by 5 years. So instead of looking at discipline outcomes from 1990 to 2018, it used approximately 122,000 attorneys who were admitted between 1995 and 2014 to look at outcomes between 1995 and 2023. And as I also mentioned as well, nearly 60% of attorneys from the original 2019 study were included in the current study. So it's essentially looking at a new set of a new cohort, but also kind of looking at those same attorneys. And also, as I mentioned, some of the attorneys from the 2019 study may have identified as a different race ethnicity in the 2024 study. So in the 2019 FARCA study, attorneys only had the ability to identify as 4 different races. So Asian, Black, Hispanic, Latino, white, or other, and they didn't have the opportunity to identify as multiracial. But a couple of years after the study was published, the State Bar began including more inclusive racial identity categories, in addition to allowing people to identify as multiracial. And so what we saw here is that some people who were one race in the original study actually changed to be, a lot of them ended up being multiracial or identifying as being multiracial. And so this kind of plays into the results that we'll see. All right, so first starting off with just overall probation rates. To orient you to the graph, on the left-hand side in the gray is the probation rates that were reported in the 2019 FARCA study. And then in the blue bar on the right-hand side is what was reported in the 2024 study. So the main takeaway here is that Black men showed the biggest decrease in the probation rate. So they went from 3.7% in 2019 to about 3%, so almost a 1% decrease, whereas Latino and white men pretty much stayed the same. And then if we look at disbarment, we once again see that Black men experienced the largest decrease across all groups, going from 4.3% in 2019 to 2.9% in 2024. And we also saw that Latino men had a decrease from 2019 to 2024 of about 0.5%, and white men pretty much stayed the same as well. All right, so now we're getting into predicting or the likelihood that certain groups will receive probation. So once again, on the left-hand side, we see the 2019 study, and on the right-hand side, we see the 2024 study. And so essentially what this means, in the left-hand side in 2019, it was reported that Black attorneys were 2.72% more likely to receive probation than their white counterparts. And this is without controlling for any type of factors. But once we actually did control for a number of factors, so these factors are kind of listed here. So accounting for gender, the number of investigations that an attorney had, the percent of investigations without counsel representation, the year since an attorney was admitted to the State Bar, different offense types, the firm size, and as well as the number of prior disciplines. This 2.72% kind of decreased down to about 0.5% essentially, and it was no longer statistically significant. So essentially what this means is that Black attorneys were no more likely to receive probation once we accounted for all these factors. And then if we look forward to 2024, we see that once again, without accounting for anything, Black attorneys were 2.24% more likely than their white counterparts to receive probation. But then after adding in these same controls from 2019, we saw that it did drop to 1.48%. But if you can tell, it didn't drop to the degree that it did in 2019. And so what this kind of captures is that it may suggest that either the discipline practices or attorney characteristics, or perhaps even both, have changed in ways that the old controls that we used in 2019 do not capture. And so the same thing here, but looking at the difference between Latino attorneys and white attorneys in 2019, without controlling for anything, Latino attorneys were about 1% more likely to receive probation. Once accounting for all these controlling factors, they were no more likely to receive probation. And then in 2024, once again, the same thing here, about 1% more likely without controlling for anything. And then after adding in those controls, they were about 0.5% more likely. So once again, the controls aren't necessarily capturing the same amount of those disparities that we originally saw. Right, and then moving to disbarment, and so looking at Black attorneys as compared to white attorneys, we can see in 2019, Black attorneys were a little bit over 3% more likely to receive disbarment or to be disbarred. And then after adding in that same set of control factors, we saw that they actually decreased. And so this means that they were less likely to be disbarred, but not at a statistically significant clip. And then in 2024, we saw that this decrease without controlling, we saw that it was just under 2%. Black attorneys were just under 2% more likely to be disbarred than their white counterparts. And then after adding in these controls, they were no more likely to to be disbarred. And then going into Latino attorneys, we see here in 2019, Latino attorneys were no more likely to be disbarred. And then after adding in those controls, it actually turns out that Latino attorneys were less likely than their white counterparts to be disbarred. But also, once again, less than 1% less likely. And then here in 2024, essentially no difference here as well. All right, and so I mentioned earlier that, with the update of the 2019 study, there were about 60% of the original attorneys who were included in this new study. So it's like looking at a new set of attorneys, but still kind of capturing those same attorneys. So to kind of combat this, we came up with a new analysis to kind of look at this from a more recent perspective and looked at 5-year windows based on the year that complaints were received and how they ended up in discipline. And so what we see here, so on this chart, on the x-axis or the horizontal axis, you see the 5-year time periods going from 1990 to 1994 all the way up until 2020 and 2023. And then on the left-hand side is the percentage point difference in the probation rates. So for example, let's say in 1994, the probation rate for Black attorneys was 10% and the probation rate for white attorneys was 8%. That means that the difference was 2%, and then 2% is what would be graphed here. And so generally what we see here is that over time, their probation rates between Black and white attorneys has gradually decreased. It reached its peak at about 3.5% from 2005 to 2009. But since then, it's gradually decreased. And in this most recent time window, it's nearly zero. Shifting to look at Latino and white attorneys here, same thing. A little bit more fluctuation in terms of there being a little bit more likely from 1995 to 1999, but then shifting once we got to 2000 and 2004, they were actually less likely. They had a lower rate than white attorneys of probation. And then as our most recent window, we see it's nearly zero as well. And now if we shift to disbarment, so looking at the rates of disbarment between Black and white attorneys, pretty much a similar story here. It was at its peak from 1990 to 1994, where the difference in the disbarment rate between Black and white attorneys was about 2.5%. But over time it fluctuated. It even went negative in 1995 to 1999. But in this most recent window as well, it's near zero, meaning there's no real difference. And then similar story for Latino and white attorneys as well. So it actually was 0 from 1990 to 1994. It saw an uptick from 2000 to 2004, but since then, it's also near 0 as well. And this also controls for all of those control factors that I mentioned as well. All right, and with that, I will pass it over to Kulan, who will be discussing the next section of this presentation. Thank you.
Thank you, Josiah. So now we're going to shift gears a bit from race to another area of potential disparity, practice sector and firm size. Our original plan was include practice sector and firm size in the main study, but unfortunately, we found that our historic data was just too incomplete to give us any reliable results. So the good news now is that the data quality is improving thanks to Rule 2.2 that now mandates practice sector and firm size reporting. We have one full good year of data. So today I'm going to walk you through our preliminary analysis of this data, this 1 year data. Now, because most of the cases that were opened in 2024 are still open, we don't have the discipline data, so we're going to use investigation rate as proxy for discipline. Investigation rate is the rate of complaints moving into the next stage of the case processing, which is investigation. Investigation rate is not a perfect proxy because most cases do end up getting closed in investigation, but it is the best we have right now. So let's look at practice sector first. Next, yeah. So the thing that jumps out from the practice sector data are most of the cases that were investigated come from two categories: law firm attorneys and solo practice. And solo practice attorneys' investigation rate is far above the overall rate of 35%. Solo practice attorneys have 41% investigation rate, and that's not counting that small other category. And then when we look at firm size, next one, we see the same pattern. Attorneys from firm size of 1, solo practice attorneys, have the highest rate of investigation at 41%, and they also make up the most of the investigation cases. And another finding that that is noteworthy, but maybe not surprising, is as firm sizes get bigger, larger the firm size, lower the investigation rate for those attorneys. So our takeaway from the practice sector and firm size data is that we need to study the solo practice attorneys closer, not just to see if they have a higher investigation rate, but why. And that is our plan for the next few years as we gather more quality data. So now I'm going to shift to another topic, which is counsel representation. As Josiah mentioned earlier, the original 2019 study found that having a counsel was associated with better discipline outcomes, but also that Black attorneys were less likely to have counsel. So after the findings from the study came out in 2020, OCTC began sending notices to respondents, what we call at-risk letters, explaining the importance of representation and providing some resources on how to obtain it. So today, I'm going to walk you through how the data look. Since the 2019 study, we'll look at, does having counsel still matter in terms of discipline outcome, and how have representation rates changed? Do they differ by race? And then finally, the policy, the at-risk policy, was it effective in improving representation rate? So first we looked at the impact of counsel representation on discipline. We looked at about 2,000 cases closed at a state bar between 2019 and 2023, and we controlled for age, race, and gender. And we found that attorneys with counsel were 19% less likely to receive any discipline compared to those who didn't have counsel. And then we also looked at, among those who were disciplined, did counsel representation matter in terms of severity of discipline? And our answer was also yes. The next one. So this one, this graph shows how counsel representation and discipline severity are linked. The discipline, so the graph shows representation rates for each of the discipline types, and discipline is ordered from the mildest to most severe, starting at private approval to disbarment. When we look at the milder end of the spectrum, we see that private approval and public approval discipline had higher counsel representation. And then we look at the most severe end of the discipline, attorneys who were disbarred, only 29% of those who were disbarred had representation. And we also ran regression analysis, and our analysis also confirmed what we see on this graph, that discipline outcome is associated with counsel representation. Next. So now we're going to look at how have representation rates been trending over the last 6 years. Generally, representation rates have been rising, but the gains are not equal for different races. White attorneys in 2018, they started at 15% representation rate, have been gradually increasing and kind of leveled off at 23% for the last 4 years. And white attorneys, of course, kind of follow the overall trend, the gray box, gray figure at the end, because they make up 65% of our attorney population. But then when we look at Black attorneys, Hispanic attorneys, and Asian attorneys, we see an uptick, but then we also see a drop in the last 2 years. Overall gains for Black attorneys, for example, is 4 points from 14% to 18%. Hispanic attorneys actually now have a lower representation rate than their beginning 17% in 2018 and now 16%. And we don't know, we have guesses, but we don't know the reasons for this drop for these groups. And I think that's another area of future research. Next. So the last part of the analysis was to see if the at-risk notice had any impact on representation rates. So as you've seen on the overall representation graph that we just saw, the rates have been increasing since 2018, and then we saw some drops for some groups. And this graph shows a monthly representation rate data. Just kind of helps us to see if there's a impact from the it helps us to pinpoint the impact a little better than the overall annual representation rate. So when the reform was launched in November 2020, the representation rate had already been going up, and that trajectory kind of continued till 2022, and then it's been dropping. So when we did a statistical analysis, we didn't find that the reform actually had any measurable impact on representation rate. So our takeaway from the representation analysis is that council representation still matters for discipline outcome, both in terms of likelihood and severity. And representation rates, unfortunately, have not been, the gains in representation rates have not been equal for Black, Hispanic, and Asian respondents. And finally, the at-risk notice policy that we launched in 2020 didn't have a measurable impact on representation. So our hope is that our findings will lead to additional policies and measures to improve attorney representation. So with that, I will hand it off to Kwei.
Hi, everyone. I'll be presenting on the last segment of our presentation, which is our analysis of the complaint archiving policy. So this was a policy that was enacted in 2020, mainly as a response to the Farkas study in 2019 that found that there was a large disparity in terms of the prior complaint volume between different groups of attorneys, specifically that Black attorneys and Latino attorneys had a much higher number of prior complaints than white attorneys. And so how this policy works is that OCTC in 2020 began archiving older complaints, which essentially make them invisible to staff, OCTC staff, during the complaint review process. So they just can't see them at all. And so not all complaints get archived. They must meet a certain set of criteria. So first, the complaint must be filed at least 5 years ago. The complaint also can't result in any formal discipline or any alternatives to discipline. The respondent for which the complaint is about also can't have an open complaint, and the respondent can't be disbarred or resigned. And so how this policy is trying to work is that, one, it will reduce prior complaint volume across the board for all attorneys, but ideally disproportionately benefit, right, attorneys with higher complaint volumes, which usually tend to be attorneys of color. And so one of the first metrics that we can evaluate the policy on is just the number of average visible prior complaints for different demographic groups. So what's going on in this figure is that in each sort of set of bars or pair of bars, the left lighter blue bar represents the before policy average in terms of the number of prior complaints they have, versus the right, the darker bar, which is the after policy average. We also have two horizontal lines, the orange lines and the yellow lines, which represent the average number of complaints collapsed across race. So basically what this shows is that before the policy, for all male attorneys on average had 19 prior visible prior complaints, versus after the policy, they now have on average 9 visible prior complaints. So basically the bars show the average visible prior complaints for specific racial groups, whereas the orange and the yellow lines show it collapsed for the gender across the board. And so there are sort of two different ways we can interpret this data. The first is to just compare the before policy and after policy averages for each specific group. So this is comparing the light blue bars to the darker blue bars in each pair. And so we can see across the board for all groups of attorneys that their average number of visible prior complaints has dropped drastically as a result of the policy. And so this shows us that the policy, to be expected, is effective at reducing the average number of visible prior complaints for attorneys for all incoming new complaints. The second way we can look at this data is to also compare each group's average, each specific racial group's average to the average for their entire gender. Essentially, relative to their gender, how much do they stick out essentially as an outlier? How far away from the mean are they? And so we see before the policy, specifically for Black male attorneys and Latino male attorneys, that their average visible prior complaint volume is much higher than the average for all men, right? 23 and 25 compared to 19, whereas white male attorneys on average had 18 visible prior complaints, which is about at the average, or if not lower than the average for all men. And then we see actually after the policy that now the average visible prior complaint volumes for Black male attorneys and Latino male attorneys, 9 and 10 respectively, are much more in line with the average number of complaints for all men, which is sitting at 9. So they are still relatively higher compared to white male attorneys, right? But actually much more in line with the average for their gender as across the board. And so we also see similar patterns in terms of the effects or changes in terms of visible prior complaint volume for female attorneys as well. Next slide, please. The second metric that we can look at in terms of evaluating the archiving policy is the proportion of attorneys who have 10 or more visible prior complaints. So what's being shown in these bars is the before and then post policy, essentially percentage of attorneys who have 10 or more visible prior complaints. So the light blue bar is the pre-policy percentage, whereas the dark blue bar on the right is the post-policy. So we can see again across the board, consistent with what we just saw on the previous slide, that the number of attorneys who have 10 or more visible prior complaints has dropped drastically as a result of the policy for all groups of attorneys. And so this shows that the policy is effective at reducing the number of essentially attorneys that have a very large volume of prior complaints. However, when we look at sort of the relative change in terms of those attorneys with 10 or more visible prior complaints, we see that the percentage of Black and Latino male attorneys with 10 or more visible complaints is still much higher than that of white male attorneys. So even post-policy, 11% of both Black male and Latino male attorneys have 10 or more visible prior complaints, whereas for white male attorneys, that percentage is only at 6%. So even though there has been a drastic decrease in the number of attorneys with high complaint volumes across the board, we still see that there's still a disparity in terms of those who you might think of being flagged as having a large prior complaint volume. Next slide, please. Okay, so the last metric that we can evaluate the policy on is the investigation rate. So these bars show the essentially likelihood or percentage chance of a case getting forwarded to investigation for various demographic groups. And again, similar to all the slides before, the left bar shows the pre-policy percentage versus the right bar showing the post-policy percentage. So again, because the number of visible prior complaints has gone down for all attorneys, we would also expect that the chance of their case getting forwarded to investigation is less likely post-policy because there's essentially less prior history, right, for OCTC staff to see. So we do see across the board that the investigation rate for all attorneys, regardless of demographic group, has gone down. But we still see that there's a disparity in terms of their post-policy averages when we compare them to each other, specifically for Black male attorneys with a 44% investigation rate and Latino male attorneys with a 45% investigation rate, compared to white male attorneys who have only a 40% investigation rate. And so we did some regression analyses to see whether basically that this difference in investigation rates could be explained away by the number of visible prior complaints. So basically, does the difference in visible prior complaints between two different groups explain the difference in investigation rates between those two same groups? And we found that that's actually not the case, that Black male attorneys are still more likely to have their cases forwarded to investigation compared to white male attorneys, even after controlling for the number of visible prior complaints. And so what this suggests is that there actually may be that these disparities actually may stem from factors that are beyond just prior complaint volume. Next slide, please. Okay, so just to wrap up, in terms of the kind of key takeaways that we presented today, the 2024 update, building on the 2019 studies framework, shows that discipline gaps have been narrowing over time, and a new trend analysis finds that disparities have been trending towards zero over the past 5 years. And in 2019, as Josiah said, there were control factors such as gender, number of investigations, and offense types that explain most of the discipline gap. But in 2024, they are now leaving a larger unexplained proportion of variance, which indicates that there may be new or shifting influences beyond the old controls. And this really underscores and highlights the need to identify these additional factors and understand exactly what role they play in attorney discipline. And as Kulan presented, our historic data on practice sector firm size and practice area are very limited. They have been much improved since the introduction of Rule 2.2 in 2023, which allows us to do more, I guess, robust analyses in 2024 in terms of looking at the different disparities in discipline between these different types of attorneys. And so future analyses will also incorporate these areas more fully, and improving practice area data quality is one key area of focus for us over the next few years. Kulan also talked about counsel representation, in that counsel representation remains lower among Black and Latino attorneys, and that further efforts are needed to improve access to representation. And finally, as I just presented, although archiving has lowered disparities in the average number of prior complaints, so just prior complaint volume, Black and Latino attorneys are still more likely to have a larger share of attorneys with 10 or more complaints, and are also more likely to have their complaints investigated. And to address this, we suggest that the archiving policy may be assessed for possible refinement. So for instance, should certain types of complaints be subject to archiving in a different time frame? So there are certain, I guess, composition or case types that are more likely to result in, or like play a larger role in the disparities in terms of prior complaint volume that we see. Maybe we feel like those complaint types should be archived maybe at a faster rate, right, than others, to sort of better account for this difference in prior complaint volume. And yeah, that is it for us. And thank you very much for listening, and we are happy to answer any questions at this time.
Thank you for all of that information. I know it was a lot, and I'll remind folks that the study is attached to the public agenda that was circulated in advance of the meeting. So the slides and that data are all available to the public and to our committee members and representatives. I'll open the floor for questions or comments. Justin?
I was wondering, as a non-statistician, right, I mean, y'all have done some incredible work that I can't quite understand. And so I'm sitting here thinking that members of the public are going to look at these numbers and still think there's a huge disparity because they don't understand controlling, right? You know, accounting for controls. And so I was wondering if you could explain the control process just a little bit more, because I want to make sure, I mean, some of the numbers are encouraging, but before we congratulate ourselves and continue investing in the same programs, I'd like to make sure that we still actually have progress, and that it's not just that we started counting things differently. And I don't mean that in a dismissive way, but I mean, did we, in 2019, did we over count, you know, the disparity, or now are we undercounting it, or is it actually as good of a news, you know, positive and negative, but is it really actually good news? So again, with much respect, because I took stats once, but that was it. Can you help me, unless nobody else has a question, in which case I'll go study, but.
Similar, yeah. Como, I think, was something.
Anybody from our panel that wants to give us a brief Statistics 101 overview and explain the regression analyses and controls?
I was hoping to be a little more targeted, but
I can take a stab at it. So when you're looking at a problem, when you want to look at the association between two things, you don't want to just say that these two things are related. When you're looking at the association between two things, you want to hopefully, as best as possible, kind of take into account these factors that also might be playing a role in those disparities. So the more factors you can put into a model to kind of account for those relationships, the closer you get to saying that, okay, these actually have a relationship. And as Kulan kind of mentioned in her analysis, like especially in terms of like practice area, we know that's a huge area. Firm size, we didn't have reliable data, so we think that in the future those will probably be important key factors to kind of include and kind of account, because we've seen, even not even related to discipline, but other outcomes, firm size, practice area, those play a major role. So it's really just trying to take as much information as you can to look at the association between things and account for those things, if that makes sense. I don't know if that's helpful.
so maybe can I follow up and explain a little more my question? Of course, I understand those concepts. What I was trying to understand is, when we're looking at the discrepancy between Black male attorneys and white male attorneys, and I think one of the notes was, then we accounted for age, years of practice, and the gap came down. That is what I'd like to try to understand. How did that function, right? Are we talking about, there's more older white male attorneys, and you know what I mean? Like, where, can you explain that bit, how we went from that jump, please?
Can I ask a follow-up?
Yeah.
Because I have a similar question. When we're controlling, is it that we're just sort of siloing those groups of like Black male attorneys in this age group compared to white male attorneys in this age group? Like, is that how the controlling works?
Yes. In a simple answer is that we are kind of creating a level playing field by each of the factors that we're controlling for. So that is essentially what we're kind of doing.
I think Tristan still has their original question though, which is there an explanation in terms of a longer years that have been covered, or different analyses and controls that were used, that helps to explain what we've seen between the 2019 and 2024 studies? Did I accurately get that?
Yes.
Okay.
Yeah.
I think maybe the shortcoming of the 2019 study was it included a 30-year span, and a lot of things can happen in 30 years. It was 5 years ago, in a lot of the complaint and discipline data were also results of the bank RA housing crisis related cases. So I think that in the 30-year period that we were covering in 2019 were different than the 30-year period we're looking at. But the main finding and analysis that we included in the study was to look at case processing by 5-year increments that the first year didn't do. So we are looking at OCTC's case processing for the 5 years, not 30-year period. So, and then when we look at that, the results the trends look much better now than before. So
It seems to me like, the problem of 4 different people standing around an elephant, one's touching the tail, one's touching the ear, one's touching the side, and nobody knows it's an elephant because they've dialed in so closely to what they're touching. And then, they can feel good about, hey, this is a rhino, or hey, this is a horse. And yet it's an elephant, right? I mean, I think we still have a discrepancy problem in the discipline along racial lines. And I'd like to find a way to make sure that we can value the information without parsing it down so tightly that now we can say, yay, if I was a Black male attorney, I'd still be very unhappy, right? I think.
And female, I mean, those trends were also concerning to me as well, which, sorry, I don't know if I'm speaking loud enough. I appreciate and am glad that we have put attention on the disparities between male attorneys, but I also noted that Black female and Hispanic Latino female, Latina attorneys were, I was like, Latino female does not feel accurate. Was still, while lower numbers, although women in general and non-binary in general had lower numbers, there were still disparities there that were concerning for me. So my question was going to be, do we have a sense, Josiah, Kulin, Kevin, you may know these, or other representatives from the state bar may have a sense of programming, policies. You alluded to you talked about the archiving policy, but other things that were put in place that you might think we could attribute some of these lowered numbers to be able to get a sense of like, are we again somewhat congratulating ourselves for things that we had nothing to do with or we had everything to do with, and then think about how to replicate or scale those, especially if we see the numbers leveling off or even going back to those pre-trends. That makes sense?
Yes. And that was the key question on our mind when we were running the analysis, what part of it is because of the practices, OCTC's practices or policies, and what part of it is just what's happening in the outside world. And unfortunately, I don't have a good answer for you. And to keep looking at those factors, especially the ones that we didn't include in the control, is on our agenda, research agenda going forward. So Josiah and Kiwi, do you want to add?
I'll add that like our regulations division does a lot of the outreach and support for attorneys in terms of not only one, like trying to get them to report and stay in compliance, but in other words, like support their practices, keep them out of, receiving complaints, getting involved in the discipline system. And they too are also very interested in this idea of essentially what we call like a risk analysis, right? Identifying attorneys that are most likely to have, issues in terms of receiving complaints or running into problems with their compliance. And a lot of these same factors emerge, right? There are differences we see in practice, sector, firm size, race, gender. And so they are doing a lot of outreach in terms of, sending out surveys, providing different communications to try and support specifically groups of attorneys that we see that have higher rates of complaints of non-compliance, to try and support them better. And so I think maybe partially some of these results might be able to be attributed to that, but it's unclear without really a true study to know.
I have a follow-up. I see Trustee Good's hand, and she may actually be planning to answer this, but my follow-up question is, if I'm recalling correctly from prior presentations, one of the major areas that came out of the Farkas study was that these were complaints related to managing funds. And I'm wondering if that holds true, and if so, perhaps an area of further study is if there have been measures taken towards education and support for solo and small practice attorneys around how they manage their funds to reduce those number of complaints. That's something that comes to mind for me. Is that
There
correct?
has been more reporting and support for attorneys reporting around their client trust accounts over the last several years. And so that is, I think, a good question.
Okay.
Yeah, and the regulations division does do like basically what you're talking about, the CTAP reporting. And they have been especially doing a lot of like educational courses over the last few years in terms of providing attorneys more information on how to report, the importance of reporting. And so I believe we've seen the number of what we call like bank reportable action cases, which is when an attorney overdrafts their trust account. We've seen that number of complaint go down year by year. I believe there are still like disparities in terms of like Black attorneys are more likely to have bank reportable action complaints than white attorneys. But overall, across the board, we have seen that number go down, which shows that at least there has been some effectiveness in some of that programming for specifically for trust accounts, which is a big problem for attorneys right now. So
Did the 2024 study also look at types of like the type sector of complaint? Did I miss? Sorry, I had to step out. Did we look at like, were they more likely from 2024? I see Josiah nodding, so maybe you did and I blanked. I apologize.
Yeah, we did look at the difference in the likelihood of discipline based on the different offense types that were related to complaints. We did look at that.
Okay, maybe we can share that data just so that we can continue to think about interventions that maybe can be continued or developed to try to level that and lower it.
Yeah, sure.
Because I'm thinking I'm thinking as I go, like even at our school or other schools, we've developed a course for students who are interested in being solo attorneys. I would be very interested in thinking about what we could teach or I could suggest to be taught in that course around managing client funds or other things that might target the issues that we see leading to complaints after 5 or so years, right? So that's where my brain is going to what can we do or encourage in the profession to head these off before we even get there.
See, we have hands up from Sarah and Alana. Sarah, let's start with you. You're muted,
Still-
Sarah.
Sorry. Shalak, very quickly, to your point, there has been a number of changes to CTAP reporting over the past few years for obvious reasons. Steve Moad at the bar heads up that program. He's done some presentations on it to the Board of Trustees. I'm sure that he would be delighted to do it to COAF. So, and frankly, the CTAP reporting program has been tremendously successful, which is heartening to hear. So you might, plan that for a future meeting, maybe 10 or 15 minutes from Steve to sort of talk to you about that. And then two, one thing I noticed in this presentation that maybe Josiah, Kevin, and Kulan might want to address is changes that were implemented in the wake of the ad hoc commission on the disciplinary system, issuing, report and recommendations, and then the board collectively adopting certain of those recommendations and sending them on to the Supreme Court. Some of those were adopted by the court, and there are several, I would say, quite critical issues that are currently pending before the court that have not been acted upon, including potential sort of exculpation, remediation, things like that. But that I didn't notice that this talked about the effect to which some of those changes may have resulted in narrowing racial disparities. They're still there or not. So just wanted to flag that as perhaps something that the 3 percenters might want to address. Thanks for
Thank you,
humoring
Sarah.
me. I know I'm not supposed to
And-
talk.
And Alana Matthews, our new liaison from California Lawyers Association. Thank you for being here for your first meeting. Welcome.
Thank you for having me. Yeah, I also had a question and then also clarification. And because I'm a liaison, am I not supposed to talk? Please let me know.
Go ahead.
But I wanted to know if there were other factors. It looks like all of the data was external. So, and this may be in line with some of the recommendations, but I wanted to know if there were any internal factors such as training or just greater education or awareness for those who are conducting the investigations, because even if we do parse it down by, age or practice type, there still seem to be some disparities, even though, it may be trending downward, but still looking at what is the root cause of that disparity. And it may not always be around the, demographic information. So I just wanted to know if that was one of the factors that were considered. And I know in the future, there was mention in the report that there are shifts and influences, and that it underscored the need to research that a little bit more. But I wanted to know if you had identified any of those influences, so that you would know what to focus on if there is going to be further research that's going to account for that. That's it.
Josiah, Kevin, Kulan.
Sarah, do you want to take this one, or I mean, you can add in the analysis, main analysis, we didn't look at internal factors, although we have discussed possibly looking at the investigation teams' demographics themselves, if there's any relationship to the cases they process. But your point is well taken, and I think we should look into the changes that OCTC made in their training or policies to see if there are any impact on the case outcomes. So, thank you.
Kristen?
Yeah. I was hoping, I wanted to draw attention to the discrepancy between Black women, Latina women, and white women. If you look at 16 and 17, the figures 16 and 17, it seems to me that the change in archiving the visible complaints has not helped Black women at all, in a way that it seems to have helped some of the other attorneys. Do we have any follow-up plan on that, or any idea why that is statistically? I mean, I can imagine, anecdotally, but.
Sorry, you said 16 and 17. Are those the slide numbers that you're referring to, or the?
Oh, the figures.
Oh, okay, the figures. Sorry, could you just tell which figure are you referring? I'm looking at the slides. I don't see numbers on them, but maybe are you looking at the report?
Kevin, it's the figures in the report.
Oh, okay.
I'm sorry.
No, it's my bad.
Figure
Yeah.
16 is the average number of visible prior complaints by race, ethnicity, and gender.
Mhm.
And it has the kind of the 4 different categories. And then figure 17 is percentage of attorneys with 10 or more visible prior complaints by race, ethnicity, and gender. They seem to me, yes, perfect.
Thank you,
They seem to
Josiah.
me to really be connected. And I know we were talking about some good improvements for men, but I don't see those improvements helping Black women at all. And I was just wondering if we could address why.
Yeah, so in terms of when you say there haven't been improvements for Black and Latino women compared to white women, after the
Black
policy now, they are all at an average of 4 visible prior complaints, right? Whereas prior to the policy, Black women compared to Latina and white women, right, had more visible prior complaints. So could you maybe clarify for me what you mean by there's still a disparity, or?
Absolutely.
Yeah.
When you basically look straight down between the 2 figures, you've got Black women before policy was enacted at 13 visible complaints, afterwards 4.
Yes.
But then when you go down to the percentage of attorneys with 10 or more visible complaints, you've got 27% for Black women and 5% after the policy. Then you look over to Latina women, and you've got 9 prior and 4 after, right? You've got that average. But when you look down, theirs dropped significantly more than Black women.
Yes,
in
I
the
see.
same
Okay.
way that the white women complaints also dropped. And I'm wondering why we haven't been able to make any progress there with the Black women and the visible complaints helping their disciplinary journey.
Yeah, so that's a great point. And so what I can think of is that the policy, right, has certain criteria that it archives complaints on, right? They have to be filed at least 5 years ago. You can't have an open complaint. And so even though we see a great reduction for Black women in terms of their average number of prior complaints, right, we still see them having a disproportionately higher percentage, right, of what you're pointing
Yes.
out of those with 10 or more complaints. So this essentially suggests that even though the numbers are going down, there's still a lot more Black women with high or like outlying, right, numbers of complaints. And so probably what this indicates to us is that they're not, something is preventing them from receiving the full benefits of the archiving, right? In the same way that we still see for on the men's side, right, that Black and Latino men, right, still have much higher percentages of attorneys with 10 or more compared to white men. And so I think we've been thinking about why this might be the case for a while. And one of the criteria for archiving is that you can't have an open complaint. And so when we think about, who is most likely to have an open complaint, it's attorneys who receive more complaints, right? So in that sense, it's actually almost they're unable to sometimes actually receive the archiving for that complaint if they always have an open complaint. And so those attorneys, for instance, because Black women on average before the complaint, before archiving, or just naturally have a larger sort of constant stream, right, or number of prior complaints coming in, that you might expect that they are more likely to have an open complaint at any time, which would be essentially preclude them, right, from having that complaint archived. And thus they're left with like a greater number of complaints that are unarchived compared to Latina women or white women who might have less complaints, right? Who actually are able to have their archived or complaints archived because they don't have something open at the time. Does that make sense? It's like this
It does.
weird paradox, and we're not sure what the best way to address it because we understand the reason for, having that criteria of not having an open complaint. But at the same time, it almost works against the policy, right? In some ways, of preventing people from actually having their complaints archived. So I think that's a possible policy change we might think about suggesting, right, to OCTC whenever there is an opportunity to refine it, about maybe making it a little bit more nuanced so we can avoid something like this.
Well, okay, I appreciate all of that, Kevin. And, it's not natural that Black women would have more complaints open. And the reason that I'm focused on this so much is that Black women did not receive the same benefit as Black men did compared to Latino men, right? So Black women and Latina women, they're nowhere close to the same. So there's an outlier there. There's something going on there that I think is probably really needs to be addressed. And again, with tremendous appreciation for the work that you've done and the fact that we can even look at this, I think is really awesome. So thank you for that. But I'd love to know what we're going to do in that regard.
I think that might be outside the purview of the folks that are presenting.
Okay.
Yeah.
Yeah,
But
I was just gonna say, we will definitely put it on our research agenda. It's an interesting question. But beyond that, we can't promise to much because we are analysts and researchers. So.
I appreciate that. Tara, you have another?
Yeah, I have another question related to the representation data. Do we have any data on why they might have not sought out representation, or where those who did seek out representation, where they found their representation? Like I'd like to know the source of representation, particularly if it's someone who, if it's a law firm, it's probably coming from that law firm, especially if it's a large law firm. So I appreciate that you're going to drill down into the law firm data. But if they're a solo practitioner, is it a family member? Is it a close friend from law school? Or are they seeking other resources to get representation? And then also further to that point, if someone decided that they weren't going to seek out representation, why didn't they do so?
We don't have that data, but again, it is great questions. we should include it in our future research agenda. The thing, I mean, we did try to see if we can see the council's demographics to see if there's any patterns we can spot, but unfortunately our council, the data that we had was not very complete, so we didn't include anything on that. But definitely, and especially when we study solos more, we'll ask those questions as well.
I think that is a really interesting question, Tara, particularly when it comes to the disparity between large firm, solo practitioner, disciplinary rates, and whether it's couldn't find an attorney, couldn't afford an attorney, didn't think they needed an attorney. It would change the outreach that we might do to address that factor. It's a really good point.
And further to that point, I know I believe you mentioned earlier in the reporting that you have this information, but if we could also see that when we are able to drill down on the representation or lack thereof, the age ranges of these folks, I think would be really interesting to also see.
Mm-hmm.
I think our theme is that we want more data. We know that you've done so much work with the data, but it's so helpful because it is showing us some interesting trends, and that will inform likely recommendations for what we can do to address those issues. Any other questions or comments from anybody?
If you will allow, I have one more.
Yes, go ahead,
This
Tristan.
one I think is easier. I'm wondering if, especially from Tara's comment, if there would be maybe some benefit to a survey to past disciplinary recipients of why they didn't have counsel. If counsel had, for example, this is going to sound outrageous, but if counsel had been provided to them, similar to what the public defenders are doing for our criminal justice system, would they have taken advantage of it? Why didn't they, et cetera? Because as much as that sounds scary to everyone, this is people's livelihood, right? So I think that if people aren't getting counsel because they can't afford it, that's something that we're going to need to address.
Yeah, that is exactly what I was
please.
thinking when I said we will study this more is surveys, although the response rates are not great, but
Sure.
I'm sure we can glean something.
Yeah, I think it's a two-part issue. I think it's one, figuring out reasons why people aren't getting representation, and then taking a step back, what is the actual population of representation? Like, I feel like we don't have a great grasp on who does provide this representation and how readily available they are. So I think that's another part of the issue as well.
And I recall from the 2019 study that there was a recommendation for a appointed counsel program, but unfortunately, due to the state bar's budget, that there's no funding for that.
I
But
understand.
that was a recommendation. So I think
There may be a whole
Yeah.
pool of attorneys who would be willing to do some of that pro bono.
And I see Sarah was nodding her head and has lowered her hand, so I take it that's what you were going to point out. Okay, thank you.
And what we do
Can I
Mm-hmm.
know
add-
from, sorry.
Go ahead.
And what we do
No.
know from, talking to OCTC just informally is that there is a wide range in terms of like the capabilities of attorneys who represent, right, respondents in cases against OCTC. As you said, there are some that it may just be your friend or family member. They might not really know like all the state bar rules, right? Versus there are other attorneys that are like well known by OCTC staff who like are like specifically there to represent people against OCTC. They might have been like previous OCTC employees who like know all the procedures and know all the different practices about like how to reduce your discipline. So in that sense, I think that's also something really important to understand about like, do people have the awareness, right, that there are these attorneys out there, and like the access and resources needed to, retain them.
I also want to add to our discussion about policies and measures to decrease disparity. One of the policies that we're not the main goal of the policy, but I think it will have impact is the diversion policy, where the attorney bridge program that will divert non-serious like communication and return of files from OCTC, so those cases never become a complaint against someone. And then also the upcoming MFA remediation program that will do similar things for fee-related disputes, etc. So those things are new or not launched yet, so we don't see it in the data we just showed you, but in the future, we'll see the impact of those policies in our analysis.
Thank you so much, Josiah, Kulon, and Kevin, for all of your work and your willingness to answer the many questions that we had for you today. And thank you to all of our committee members and liaisons for your participation. I know that this is an interesting issue that we've been discussing since the FARCA study came out. So I certainly appreciate your ongoing work.
Thank you, Arwa.
Yeah, thank you.
We'll move now to item 4.3. It's a presentation and discussion on the Provisional Licensure Program from Duan and Elizabeth.
So I'm just going to share my screen. Okay, so we're going to provide a little bit of background for you all to lead up to our discussion on the Provisional Licensure Program. First, we're going to walk through the Blue Ribbon Commission on the Future of the Bar Exam, the original Provisional Licensure Program, or the PLP, the expanded program, which we'll call the Pathway Program, some surveying that we did, as well as the 2025 Provisional Licensure Program, and then our discussion. So as a reminder, the Blue Ribbon Commission on the Future of the Bar Exam studied exam and non-exam pathways to licensure. We had 2 COAF members participate on the commission, Judge Kristen Rosie and Ryan Harrison. The final report and recommendations of this commission were published in June 2023. And then following that, there was a recommendation to the Supreme Court regarding a non-exam pathway, including a proposed portfolio bar exam. And I want to note that the final report and recommendations to the Supreme Court, they weren't able to secure a majority position either in support of or in opposition to alternatives to a traditional bar exam. And so that's why there was a follow-up. And so at the time of the commission's work, COAF discussed some concerns that they had regarding a non-exam pathway. So this included oversight of supervisors to ensure safe, positive experiences. There was one particular study of a Canadian program where there was harassment and abuse. And so that was a concern that COAF discussed. There was also concerns about the availability of supervisors willing to participate, the ability of participants to find supervisors, and then also the perception of a 2-tiered system if there was both an exam and a non-exam pathway. So the original Provisional Licensure Program was developed in response to the COVID-19 pandemic and the delay of the administration of the July 2020 bar exam. In July of that year, the Supreme Court directed the State Bar to implement a temporary supervised provisional licensure program to allow 2020 law school graduates to practice in specific areas of law under supervision of a licensed attorney. They established a court rule to establish the program, and it was we want to be clear that this was not a pathway to licensure. Provisionally licensed lawyers, or PLLs, that participated in this original program still had to take the bar exam to obtain a license to practice law. We also want to note that we had directed funding to fund 20 PLLs who worked at legal aid organizations in 2021 and 2022. So with the original program, the participants were required to be 2020 law grads, have not passed the bar exam, and have a positive moral character determination or submitted one that was pending, either passed the MPRE or within 30 days of entry into the program completed 4 hours of ethics e-learning, and then completing a 10-hour new attorney training program within a year of entry to the program. They were also required to be supervised by a California licensed attorney. The original program had 912 participants, and there are currently 67 remaining that haven't taken and passed the bar exam. And then the Pathway program. So this program was developed in response to public comments as the working group that was working on the original program were developing rules and guidelines around the program. And it also coincided at the time when the Supreme Court lowered the cut score on the bar exam. And so the Supreme Court developed Rule of Court 9.49.1 to establish this Pathway program, which expands the original PLP to include those who scored between 1390 and 1439 on the bar exam administered between July 2015 and February 2020. There were, in addition to the requirements of the original PLP, participants in the Pathway program also needed to complete 300 hours of supervised legal work and have a positive supervisor evaluation. The program was launched in February 2021. There were 1,023 participants and 149 remain. So either they haven't yet completed the 300 hours of supervised legal work and received the positive evaluation, or they haven't taken it past the bar exam. So earlier this year, or just last month, earlier this month, I mean, in response to issues related to the February 2025 bar exam, the Supreme Court approved expansion of the PLP. So this would open up the PLP to first-time test takers who registered but withdrew from the February 2025 exam, or first-time takers who failed the February 2025 exam. The program would begin in September of this year and extend through December 2027. And this extension date applies to both newly eligible participants as well as those who are currently in the PLP program. And then the state bar is authorized to assess reasonable fees to cover the cost of the program. So there are 1,026 individuals who are eligible to participate in the 2025 PLP. Sorry, there's a typo there. And this includes 410 first-time applicants and 616 first-time applicants who withdrew from the program or from the exam. And here's some, you'll see the composition of this group. And I want to note that it is more diverse by gender and race ethnicity than the attorney population. You'll see females that are eligible to participate are at 55.8%, and there are 44% female attorneys. By race ethnicity, it's actually a large overrepresentation of Asian participants who are eligible. There are only 14% Asian attorneys. For Black participants who are eligible, it's 5.4% versus 3% of attorneys. And then for Latino applicants who are eligible, it's 9.8%, and Latino attorneys make up 6% of the attorney population. So it is more diverse by gender and race ethnicity. So we also wanted to share the findings from a 2022 survey of participants at the time. So this was sent to over 1,500 former and current participants of both the original and the Pathway program, as well as to their supervisors. And we had a response rate of 50% of participants, 34% of supervisors, and the survey was also sent to eligible PLLs that did not participate in the program, and 48% of those responded to the survey. The survey included questions related to demographics, compensation, satisfaction, benefits, challenges, and views on continuing the PLP. And so I also want to note that we're just going to highlight some key findings today, but there is more information in, we have a slide of resources. So there's more information on the survey there, specifically in the letter and recommendations regarding the PBE. Okay, so overall, 77% of the respondents spent their time as a PLL in the private sector, 15% in nonprofit and 5% in government. Interestingly, 24% of PLLs worked on a volunteer basis, with the remainder being paid. And overall, similar to the eligible participants for the 2025 PLL, the pathway and the original program had a more diverse participant pool than newly admitted attorneys. And there were no significant distinctions in findings based on race and gender. So there was overall very high satisfaction, both by supervisors and PLLs participating. And then the challenges that PLLs reported were actually very similar to those that were identified by COAF in the discussions related a non-exam pathway to licensure. 42% found it awkward to explain their status as a provisionally licensed lawyer. 36% found salary challenging, and 26% found it difficult to find a supervisor. Employers, majority of employers also found that there were benefits to having a PLL, finding that their PLLs were hardworking and allowed them to serve more clients and add diversity to the practices. Employers also experienced some challenges in supervising PLLs, noting that they needed more direct supervision, weren't able to handle work that other newly licensed attorneys could, and needed more training. This slide here, we've included, because of the concerns related to discrimination, bias, and harassment, 4.4 of PLLs reported discrimination or harassment, challenged them to a small extent. 3.2 reported it challenged them to a moderate extent, and 2% reported that it challenged them to a great extent. Those who experienced discrimination or harassment still strongly supported supervised practice. They were more likely than other licensees to recommend extension of the PLP. They also reported the same high levels of satisfaction. They also explicitly noted that discrimination and harassment came from clients, opposing counsel, judges, and other participants in the legal system, and also recognized that harassment and discrimination were not unique to supervised practice, but that they had experienced these types of negative behaviors in other workplace and academic settings. They also found that the benefits of participating outweighed the costs of experiencing the discrimination and harassment. Related to compensation of PLLs, we wanted to look at who was paid and who was unpaid. And so you'll see here, and I'm sorry that it's quite small on the screen, but the main takeaways are that a disproportionate number of Black PLLs were unpaid, 19% unpaid versus 9% of the overall participant pool. And Hispanic and Latino participants were less likely to be unpaid, 13% unpaid versus 17% of the overall pool. And men were more likely to be unpaid, which is surprising, especially considering that there were more women who were participating in the program. And then graduates of California accredited, unaccredited, registered schools and closed schools were disproportionately unpaid compared to those from ABA schools. And we are conducting additional analysis, a regression analysis, to see if race-gender disparities would disappear once we control for law school type. And so given that we will be developing or expanding the PLP program, we wanted to bring this discussion to COAF because it has raised some concerns about the program in the past. And we have some starting questions here to get us started to think about, is the State Bar collecting the right data? What additional data might be helpful to continue to collect or begin collect? And then given concerns related to compensation, supervisor oversight, are there mechanisms that can be developed to ensure participants have a safe and positive experience? And then how can the State Bar support PLLs? Dawn and I have some ideas, we'll share those in just a moment. But I also wanted to note to thank Trustee Good and Trustee Harrison, Trustee Harrison was on COAF, and as was Trustee Good. They brought this to our attention so that COAF could discuss.
Elizabeth, for this information. I did have a question. So I understand the context of the PLL program fully before I ask about the additional data. So if I'm understanding it correctly, there are only certain practices that would be able to be included in the PLL program?
No.
Or no, it's any practice?
Yes.
The supervision piece is the requirement, but not substantive areas.
Yes.
Not the okay. So I guess one of my questions is related to the compensation piece. For those that were unpaid, what exactly was it that they were working on? And is there any disparity between the substantive areas that we're able to find?
That's a good question. We don't have that information currently. I'm not sure if we collected that information, but we could. I don't know if Kulan is still on. I don't see her.
I had a piece to that as well. For those who are unpaid, both substantive practice areas as well as size of firm. So I would guess, let me say, that the smaller the firm, the more likely they are to be unpaid. But I'm curious as to whether or not that is true and whether or not there is any type of requirement similar to that which exists for internships, externships, for some type of payment to be made unless the organization fits certain categories. Do you all know like what I mean, where interns and externs have to receive some form of compensation unless the organization employer is government, fits certain nonprofit categories, et cetera. We deal with that with students all the time, where some employers think, oh, well, I'm hiring a student as an extern or an intern, I don't need to pay them. Often we have to educate the smaller firms to know that no, in fact, by law, you do have to give them some form of compensation. It may not necessarily be an hourly wage, but there is some form of compensation that's required. I recognize that these are not students, but I wonder if there is some mechanism to apply the same standards to reduce that unpaid category, or if we think that would hinder the ability to find supervisors. That can get complicated, but it sort of follows up on Tara's excellent point as well.
I think Kulan is being promoted back into the panel as a panelist, so we might be able to ask her if that data was collected with the survey.
Well, yeah. I think also related to what Shawanka was saying, like the size of the organization, but the type of the organization, whether it's a law firm versus a nonprofit versus a legal aid, I think that could give us some insight into the why.
I think you said that the vast majority were in the private sector with like 5% in government or something like that.
And like 14% in nonprofit.
14%.
Yeah, I mean, you've got 19% of the Black participants receiving no pay versus only 9% of the white participants, which means the Black participants twice as likely to not get paid. That doesn't feel good to me at all. Sounds a lot like sanctioned, at least indentured servitude.
I think that there was slightly different numbers, but yes, it was disproportionately higher for Black students. And I do think one of the things that we talked about from the COAF letter to the Board of Trustees was around potentially entrenching the disparities that already exist, and then not limited to, I should say, demographics, but also law school type, because if the whole point was to address folks who are coming from less traditional backgrounds, who are coming through California accredited law schools, for instance, I think the data that we're seeing is troubling on that front as well. If these are the folks that are disproportionately not being paid, is the program helping them as much as we had hoped? And if it's not, what can we do to address it?
Particularly when those schools tend to be more diverse, more
Yes.
first generation, right? Like we're sort of seeing this as cyclical.
Well, but also predatory, right? I mean, you're still ending up with loans, and then you're going to go into an environment where you're not making very much money. We're not helping those students, right? If we're creating unreasonable expectations, not to mention the fact that in the 2025 class, 410 people failed the bar. Okay, I mean, I don't love that. And then 600 didn't even take it. They just withdrew. So
Well,
what does that mean?
Well, there were.
I mean, I would love to not take the bar.
No. So, sorry to interrupt you.
No, it's okay.
Um,
I'm getting excited.
So there were a lot of technological issues with the February 2025 bar exam. And so to try to mitigate some of the impact, I think at the time, before the bar exam was administered, takers were given the option to withdraw and wait to take the July exam because there were a lot of already known technological issues with the exam.
So why are we trying to give them an alternate path instead of having them take the bar? I mean, if the problem is the bar exam, we
Would
should
they
be
still
addressing
be
the bar
required to
exam.
take, my understanding of the PLP is that they can participate in this and then by 2027 would have to sit
Yes.
for an administration of the
Yes.
bar exam.
Yes.
Sit for and pass or just sit for?
I believe sit for and pass.
Yeah, so they still have to take
Right.
the exam
So,
at some
because
point.
There were a lot of issues with the
2025
February exam. And so the Supreme Court, in addition to a lot of other,
Remedial measures.
remedial measures, expanded the PLP to address some of the issues because it really impacted those takers.
And is it too late for us to actually question the existence of the PLP? I mean, I know I was here. It was, I think, one of my first meetings where we were listening to the law schools talk about it and things like that. Is it, because it feels to me inherently unfair. It feels like a bad idea. And I know I've said that. Is it too late for us to continue to object?
At this point, the California Supreme Court has said that the PLP is going forward based on the February bar exam results.
But not
For
as,
this,
but not as an alternative
correct.
No.
pathway at this point, which I think might be
Right.
the similar concerns. This isn't as an alternative pathway to licensure. This is to provide some form of remediation
Yes.
and opportunity for individuals who were impacted either by COVID-19 or the February 2025 bar exam
Correct.
administration while they pursue taking
Yes.
the bar exam.
Correct.
But does the public understand that, right? Do
Well,
their
that goes, I
clients
think, to the
understand it?
20% second class lawyer issue and what the state bar can do to support.
I mean, there's already, discrimination between accredited schools and non-accredited schools. There's already that, did you go to a top 10, right? We understand that, that's just the reality. But setting up these younger, not attorneys to practice law. I'm sorry, I'm still really upset by this.
Let's turn back to the questions, particularly that Elizabeth and Dwan are looking for support on as we look to the next cohort that's coming up. And if there are any other questions, but I'll try to promote comments or ask for comments to solicit comments that are going to these questions about additional data that can be collected or what else the State Bar can do to support this next cohort. Cecilia, did you have something?
Yeah, so it might impact some of these questions, but I was curious about the feedback you got about from the supervisors that they felt these students were less than newly admitted lawyers. I was wondering if there was any more insight into that feedback, if those were just conclusory statements made in whatever surveys you were.
That is a good question. Is Kulan, has she been promoted? Is she still here?
I'm here, but I don't have an answer because I didn't work on the survey. But I will look into it to see if I can get more details on that.
And the reason I ask is I was wondering whether there is some implicit bias in that statement.
Sure,
Right?
that's a good point.
Kamal, I see your hand is up as well.
Yes, I was just wondering what kind of surveying was done in terms of quality of feedback received by participants, because one of the things that comes to mind is there's some interesting data out there, not specific to the law, but data about people of color, particularly women, receiving less actionable feedback, less quality feedback from supervisors. And so to me, that's a really important component of this program. And I was wondering, it sounded like I kept hearing information about whether the participants faced discrimination or harassment, but was wondering what more there is in terms of the quality of feedback and sort of the whether people received enough.
That's a great question. Not surprisingly, again, Kulan, we're going to ask what other data is out there that has been collected, and maybe a bigger question is whether there's a report beyond what Elizabeth has shared so far with us today that has collected the survey responses and perhaps more detailed answers.
I think so, and I will look into it. I recall there was a more detailed report, and I will.
So if you, sorry to interrupt you, Kulan. So if we, at the last slide of the PowerPoint that's posted, there's a resources slide with a bunch of links. In the letter and recommendation regarding the portfolio bar exam, the second to last bullet point, beginning at page 22 of that PDF, is a discussion of the survey, which has a bit more detail than was presented today.
Okay, I think there was another study, another report. So I will check the resources here and see if that report is included.
Great.
I see here in that report, my question was going to be about the type of, can we get data on the types of supervisors that the students are, or not students, but the employees are getting access to? Because I see in the supervisor qualifications, they only need to hold an active California license and not be an immediate family member. So I'm curious if, especially if they are working, once we figure out what type, where they're working at, if they're working at a small firm or whatever the case might be, if they're being supervised by younger attorneys or more seasoned attorneys, because I think that also will play a part in the biases that they might experience, and then also the type of experience that they're getting, and then the relationship between them and the clients and the client confidence.
So by type of attorney, I mean type of supervisor, you mean like experience as an
Experience, years of experience.
May I ask a logistical question regarding the rollout of the PLP for this 2025? What is the timeframe within which, maybe this alludes to Tristan's question, within which we can have a measurable impact on the experience, right? So not just like looking at data after it's done, but are there recommendations? Is it ripe now for us to give active recommendations for things to be put in place?
Yes, exactly. Okay. So that's the purpose of having this discussion today, is to figure out are there mechanisms that we can develop.
I have a suggestion.
Yes.
One is, to the extent we can, having an oversight committee or board group, something, I don't know, maybe from OCTC, why not throw more work at them, or anybody, that where supervisors are told that at some point throughout their term, random drop-in, right, or reports are going to be required or something, where we can start to assess, and I'm thinking as I'm speaking, so please forgive me, but start to assess, the quality of work that the participant is being given. Are they being asked simply to function as an ad hoc secretary? Or are they being given quality legal? Or Jezreel might think, see where my mind is going to, like clinicals, where students who are getting externships or something have to have reports that are sent in by the supervisor about the type of work they're doing. Our law schools may be ripe for providing sample paperwork or examples that might be used this could be built on. But I think to how the state bar can support PLLs, something like that might be useful for also signaling to the attorney supervisor that the state bar takes very seriously that they are in effect training future attorneys and they expect work to be given, what type of feedback mechanisms are being used, how are they receiving that feedback, and having that type of oversight done while they're being supervised. Maybe it's by quantity of numbers or hours, right? So if they have to go up to 300 hours, maybe a report or something is due at 50, 100, 120, et cetera. Where again, it's being shown, if you choose to take someone on as being supervised, here's what we expect of you. And I would perhaps ask for the attorneys, supervisors to explain why someone is not being compensated. So it is setting the expectation that these people are coming to do real legal work. They are not your free, unpaid legal intern. We expect them to be compensated and give us information as to why you are choosing not to compensate. So not necessarily that they're seeking an exception, but it's raising the bar of what we anticipate from them so that they start to go, okay, yes, at least I'm gonna cover gas, food, like something, even if it's not real salary, which I'll just put that aside, right? But something towards this.
Yeah, I think the compensation issue is a good one to look at, and I look at it from a different perspective, that if one of these employees is paid, I think the employer then expects more and may give them more substantive work. And I don't know if this is a similar concept, but I know that in law firms, right, they'll have first years start before they know the results of their bar exam. And there are those that don't pass it and then they're given some time to maybe take the next one. And I guess, I don't know if that's a similar concept where they're being supervised, someone has to say, I'm supervising the work, but those first years who might have actually failed are still given, you know, true substantive legal work. So I don't know if there's a parallel here or even if those two concepts are the same.
I'm thinking of that concept too when I'm thinking about this, and that there needs to be some sort of accountability held on these firms who are entering into this program, because if there's not, then in instances like that, there are firms who, if you didn't pass, they let you go.
Yeah.
Very quickly.
Yeah.
And a program like this is sort of a buffer for that. And so if there's some sort of accountability and saying like we're paying attention, very similar to what a law school would do during a summer associate program, that would be very helpful.
I absolutely agree with these suggestions. I mean, the protection for the PLPs, is it PLL or PLP?
PLP is provisionally licensed
Program.
program,
And
and
then
PLL is provisionally licensed lawyer.
So the participants are
Yeah.
PLLs in the field.
So the protection for the PLL should be at least as strong as the protection for legal interns, right? I mean, I'm thinking maybe, first of all, I don't understand why there's any category for unpaid. If that's something we could push on, that would be good. But when so as a provider, MCLE provider, I went through a pretty rigorous process to become an MCLE provider. And I'm not in charge of young minds, you know, well, older minds, but I'd like to see something similar. Like we could explore it at least. So maybe we don't want to close off the market for these folks if we're going to have them, but maybe they could fill out, you know, what kind of work are you going to have them done? I mean, when I was a supervisor in-house, I was always terrified of giving the students the wrong thing. Okay, I'm not giving you filing, I promise. I just need you to get this one case and then look at it. And then, you know, because I wanted them to have work product, they needed to leave the internship with something that they could use in their moving forward. And I feel like there's some quite easy, you know, pylons or that we could have the employers pass so that they're not taking advantage. Because I would imagine the desire to do that is probably pretty strong.
I would like to add a suggestion for additional criteria that there has been no, I recognize where this may go, but no active complaints within like 5 years, right? Like I think that's a relatively low bar and the person is not subject to disciplinary action or has not been. We have that internally. We will not approve a student to do an externship or internship where their supervising attorney is someone who is subject to an active investigation, complaint, or whatever. And that feels like, again, a relatively low bar for me to say that you're in good standing with the state bar if you're going to supervise. I wonder if there's a way to create a database or forms getting to the the 26% with difficulty finding a supervisor, perhaps the state bar might reach out proactively to attorneys and firms if the majority are in private practice, both of all sizes and practice areas, to encourage participation in this and then create some sort of database of a suggested starting place where people could reach out to apply or to seek this type of support so that it's not left on, do I happen to know an attorney? Does my law school happen to have a list? How engaged are alumni or not, right? But sort of removing some of those biases from it to be able to create space for people to find attorneys, and the state bar is being active in that and in supporting this measure.
Could we also consider having a 1 hour CLE for anybody who wants to be a supervisor, and maybe for the PLLs as well, separately? So we let them know what they can expect, what they have a right to ask for, what they should be receiving, and same thing on the other side. Here's what you should be, the kind of work you should be giving. You should be meeting with them, and they don't have to be all like absolute requirements, but you should be meeting with them at least once a week. You should be, et cetera, like the things you said from your program. I mean, that was the first thing I thought of, was at least the interns should be the same, or stronger, because interns have the benefit of their law school looking out for them. And these PLLs, they don't have anybody looking out for them. So it could be the state bar, right? Like give them that education, and so I hate the program, but here I am like all excited about trying to help protect.
And to Kamal's point, that might include training on feedback, right? Like if they're a solo who doesn't supervise anybody, they're not receiving the same type of internal support that partners, or junior partners or whatever at firms are being given around supervising attorneys, providing feedback, meaningful development. So to Kamal's point, that might be something that those supervisors may find valuable even in assessing what type of work should I be given? Should I expect a first year to be able to do? They may be thinking, 10 years ago, this is what I could do. Well, no, you couldn't. You just think you could, right? And so to right size expectations.
I think that's great. The one idea that Dawn and I have been talking about, so with the original PLP cohort, the Legal Services Trust Fund Commission, who administers the grants to legal aid organizations at the State Bar, had directed funding to fund PLLs at legal aid organizations. That directed funding, though, has been now converted to fund our summer law fellows, so that funding is no longer available to fund PLLs. However, we have been thinking about, for our legal aid organizations who take on a PLL, that are our grantees, are there some supports that we could also provide? And I think some of the things that you all have mentioned could fall into that quite easily.
Great.
So one of the ideas that we had is potentially a partnership. And I think I know everybody in COAF, but for those that don't know me, my name is Dewani Wing. I'm the other program director, 1 of 3 in the Office of Access Inclusion. And I manage the grant side and the Trust Fund Commission. So I'm the lead staffer on the Trust Fund Commission side. So Elizabeth and I, one of the ideas we thought was having some type of kind of collaboration between COAF and the Trust Fund Commission to go out there and really kind of develop some guidelines, like you were saying, some mechanisms for support for legal aid specifically. But as I think about it, some of these things that we develop can be utilized for other entities that host PLLs. So some type of guidelines, and luckily right now, the Trust Fund Commission is going to be distributing $217 million in IOLTA grants next year. So state funding is not doing well. A number of our grants are actually going to be sunsetting, but our IOLTA revenue has stayed fairly strong. So we can try to encourage programs there's a crisis in recruitment retention right now. So this is actually can be a good opportunity to recruit employees that can help kind of fill that gap. We have 3 streams of funding that are ending. Our homelessness prevention funding, which does a lot of eviction work, housing work, our foreclosure work, and our consumer debt. So Elizabeth and I and our thinking was perhaps we can develop some type of cohort experience from these kind of funding streams that are ending. And there are also kind of other groups that are especially in need, like the seniors, veterans. So this is something that, again, if there's some interest in both COAF and the commission, we can have some cross pollination and develop some of these ideas and kind of really just lean into it. Maybe we won't be able to pick like six issue areas, but based on the data, if you all want to lean into 2 or 3, and then we could again create that cohort experience, that training experience, that support experience. That's again trust fund commission and COAF. So we thought that could be an opportunity again to support these test takers that haven't passed the bar exam, but also fill the gap in need right now with recruitment and retention. So again, just a thought that we would love your feedback on.
Are you suggesting that we provide a platform for the PLLs to talk to each other?
We can do that. That could be part of
do
that.
Do we have a web page that's dedicated to the program? Because you could have a supervisor portal or supervisor, area where they can all talk to each other. Hey, what kind of work are you doing? Are you finding this form difficult? And then on the other side could be a PLL site where they might actually can make new networking connections and have sort of a the more we can empower them, the less likely they are to be taken advantage of. And so that comes with information, right, and connection.
I don't believe that exists, but those are the types of ideas that we'd love to generate.
Yeah, it doesn't have to be technically that sophisticated, but resources. Here's some, literature that you would like. Here's what you can do if you're having trouble with your supervisor. Here's what you can do if you're having trouble with your PLL, right? Just keep it balanced.
Yeah, no, so I think that's like along the lines of what we would want to continue to think about. And so leads me to our next steps.
There's one
Yes.
more that I think this group should pay attention to is the feedback that 40% found difficulty in studying for the bar exam. And if part of the point of this is to provide a buffer, a stopgap to get them to the point where they can take and pass the bar exam and be licensed attorneys, I think it is important that supervisors are made aware that these are individuals who are still studying for the bar exam. I wonder how many of those 40% who found difficulty studying for the bar exam were also unpaid. And so were unpaid at this, so needing to make these hours, work somewhere else to be able to live and trying to study for the bar exam. And if we can make those connections to alleviate, perhaps if they are paid in these hours, that reduces the need they have elsewhere so that they can study for the bar exam. Sorry, I talk with my hands. And bring those, I go back to doing it, bring those together, but whether it's in the supervisor training, which I think is a great idea, or other documentation that's given, is a reminder that similar to the first year associate who's waiting for or may need to take that extra time, these are individuals who still need to take and pass the bar, and you need to make sure that they are being encouraged to do that. Not just like, oh yeah, you have to do the bar at some point, but encouraged and mentored and developed towards that. Perhaps in what the state bar can do, perhaps there's some type of support partnership with the law schools to target these individuals. And I'm thinking across all law school categories to target these individuals and ensure that they are receiving adequate support while they are going through this PLL as a PLL to take and pass the bar exam.
Is it possible to require, I don't know exactly how the rules are going, but if somebody's working for free, that the supervisor has to pay for a bar study class and give them time at the office to study?
Wow.
The requirement, I am not sure. That's probably something we have to do research on to see like what authority we have to require certain things.
But I mean, that could be a
But that
nice,
could be,
if you actually get two times a week, you get 4 hours to sit in the office and study. If folks are also being a waiter and they're also doing this and that, I mean, that's
But I do
crazy.
know that the PLOs that were placed at our legal aid programs, I don't know how extensive it was, but we did hear anecdotally that some of them were very flexible in allowing like time off. I mean, we let our programs choose if they're in compliance with the law, what is it? Full time.
Yeah.
And some of them are very generous in providing like full time is like, a certain X, it's not 40 hours, and letting them take like a longer leave leading up to it. Again, I don't know how pervasive this is. I don't know when we can require it, but these are all things that.
Perhaps that could be part of the oversight, right? So if there's an oversight mechanism checking in with supervisors and PLLs, part of that process could be, are you receiving adequate, how much time are you spending studying for the bar exam weekly? Do you feel you're receiving adequate support from your supervisor to study for the bar exam? Supervisors, how much conversation are you having around the bar exam? Are you providing adequate support? Whatever adequate might look like from person to person, that at least could encourage them to have the conversation that says, you know, I'm the PLL saying, hey, Elizabeth, I'm so sorry. Can I take Friday? Because that's the only day I also don't have to work at my paid job in order to study. And it might just nurture the environment where everyone remembers this is the ultimate goal, is to pass the bar and be licensed.
I don't mean to cut us off, but we're running into our lunch session
sorry,
here.
so
We
excited.
We need volunteers for our COAF working group. How many do we need?
We need
Elizabeth?
2.
We need 2. Do we have 2
17.
volunteers from our COAF working
I'll
group?
volunteer.
We have Tristan and Cecilia.
You mean to work on this exact thing?
Correct.
Yes, I'll work on this.
Okay, and then,
Tristan and Cecilia.
oh, I also see Kamal has her hand up.
Can we have more than 2 in a working group?
I'm sorry?
Can there be more than 2 in a working group,
We
or are
would like
working
to
groups
keep it to
only
2.
2? Okay.
Because we will also likely have folks from the Legal Services Trust Fund Commission.
Oh, okay.
Okay, so.
Okay, I'll pass on this one then.
Okay, thank you, Kamal, for your interest. Anything else, Elizabeth?
No, that's it for this presentation.
All right.
Thank you.
Thank you. We went a little bit long here. I do want to check in before we break for lunch. Judge Diaz, I know that we were going to take your report at 1:15. If we continue it to 1:30, will that still work, or do you need to have it at 1:15? If so, that's fine. We can reconvene at 1:15.
I don't want to do that to you, but I really do need to do it by 1:15.
We will break for lunch now and take a slightly shorter lunch and come back at 1:15.
Or do you want to take her?
You know, it's.
Do you want to report now?
Sure, it'll probably take about a minute to 2. It's not that long.
Well, let's do it now then. We can
you
get
guys are
you out
great.
of here. Thank you for your patience.
You are great. All right, so good afternoon, everybody. I will be reporting on some of PAF's ongoing progress related to our 2025 annual agenda. One for the Language Access Signage and Technology Grant Cycle 7 with approval from PAF and the Information Technology Advisory Committee. The draft report with recommendations and proposed allocations to fund 17 courts will go to Judicial Council for approval at its business meeting on July 18, 2025. And then as to the project to develop training for court staff on appropriate use of machine translation tools, the National Center for State Courts, under the current language access contract with Language Access Services, provided a presentation at the June 17 PAF Language Access Subcommittee meeting on research conducted and training resources developed for court staff on the appropriate use of the California Courts Translator, which does use voice-to-text technology to enable communication between court staff and limited English proficient court users. The resources developed included 6 training modules to assist court staff with using the California Courts Translator application, as well as a tip sheet and multilingual explainer video for court users. The developed resources will be available to the courts on the California Courts Translator SharePoint site. And then the invitation to comment period for new forms recently closed related to PAF's project titled Superior Court Lactation Accommodation Procedure in All Court Proceedings. The SB 949 proposal has an effective date of July 1st, 2026. Lastly, PAF is making progress toward another form and standard of judicial administration proposal under Assembly Bill 1899 related to juror questionnaires and inclusivity. An invitation to comment is anticipated to circulate in the winter 2025 cycle with an anticipated effective date of July 1st, 2026. And that will be all for me. If you have any questions, I would refer you to Christina Resendez-Johnson, but thank you.
Any questions for Judge Diaz immediately? Tristan?
Just one. Judge, is it possible to see, when it's appropriate to see the potential jury questionnaire? I would be very interested in that.
So I will ask Christina Resendez-Johnson about that. So you'd like to just receive a copy of it maybe as a part of our meeting?
Just to take a look at it and see what's being considered and proposed.
All right.
My understanding is that it hasn't yet been circulated for public comment.
Right.
And it's related to AB 1899, which had some specific language in it that might hone you into it.
Thank you.
Yes.
All right.
Thank you so much, Judge Diaz.
Thank you.
Thank you.
We're going to take our lunch break now. We will go to 1:30. Folks, we've gotten through the big presentations for the morning. the afternoon. Even with our 15-minute break, we should still be done by, I'd say, 2:45. Okay, so thank you so much. We'll see you at 1:30. All right, welcome back, everyone. We are being recorded. I think we are public as well. Great. Thank you for being on time. We're going to go right back into our agenda. We are at item 4.4, which is the update and discussion on the DEI Leadership Seal program. And this will be an update from Danielle McRae.
Hi, good afternoon. It's good to see many of you that I also saw yesterday at our Partners in Progress Summit, which I will talk about in the next item. But let me go ahead and share my screen to get us going on 4.4. Great. Okay. There we go. Okay, so wanted to briefly start with a program overview. I think most of you have heard this now many times, but just helpful framing for folks that are newer to COAF and this program. The DEI Leadership Seal program is a program that recognizes legal employers that employ California attorneys that commit to and implement best practices related to diversity, equity, and inclusion in the workplace. Employers in the program can be recognized as either a committed employer or a seal recipient and actually receive a seal from the State Bar based on whether they have implemented those action items. And also based on the number of action items implemented can be recognized as either bronze, silver, or gold tier recipients. And we currently have about 100 programs, 100 employers in the program, including law firms, nonprofits, government agencies, in-house counsel, a couple law schools, etc. It really runs the gamut across the legal profession. But what we want to chat about today is give you some recent updates. There's been a lot of discussion and moving parts as it relates to this program in the last couple months. So as we reported in March, given the current landscape, recent executive orders, the kind of shifting environment as it relates to diversity, equity, and inclusion, the State Bar delayed application release for new employers for this program. So typically we release applications in January for the next cohort, and we did not at that time. We paused and communicated to employers that we planned to release applications in July. And we took that time, that pause, to do a review of the program parameters, the program name, and so I wanted to provide a little bit of more information about what that review looked like and entailed. At the end of last year, our Office of General Counsel did an additional kind of renewed review of the program parameters to ensure compliance with applicable laws and regulations. And then also the State Bar engaged a branding naming consultant to evaluate whether renaming the program might be appropriate to facilitate continued employer participation. As you all well know, the State Bar is continuing our diversity, equity, and inclusion work largely unchanged, but we recognize that this program exists insofar as employers want to participate in it, and so wanted to investigate whether a name change might make employers more comfortable or make it more palatable, for lack of a better word, for various employers that may either be in the program or be interested in the program. We did not at any point anticipate changing the substance of the program, but wanted to evaluate again whether different name options might work better for the State Bar. And in that review, the range of name ideas was really broad. So there were some names that were quite metaphorical, think something like Catalyst Leadership Seal or Mosaic Leadership Seal, and then some that were much more descriptive, like Access and Fairness Leadership Seal, such that it aligned with the COAF naming convention, or Access and Inclusion Leadership Seal to align with the Office of Access and Inclusion naming. That's 4 of like 80 or 90 names we looked at. So that's just illustrative of really kind of what this review looked like or could have been. And we gathered a lot of feedback from stakeholders throughout that process. So we did a survey of stakeholders through and with the consultant that we engaged, and that went to some trustees, some current and former COAF members, as well as participating employers, some participating employers in the program. And then also additionally, State Bar staff did several interviews with, again, employers in the program, various stakeholders, current and former COAF members, really spanned the gamut there. And it was really interesting because that conversation really changed over time. I think in January, February, there was more fear or hesitancy from employers, particularly as it might relate to their funding sources. We did see some employers removing the DEI leadership seal from their websites, for example. And, as we've seen organizations across the legal and other professions kind of removing DEI language from their website, the leadership seal that was also a victim of some of that website scrubbing. But as we saw, law firms negotiating with the administration and seeing the different and varying responses to that, as we saw large companies receive pushback for removing or changing their DEI work, and particularly in seeing that the firms that stood firm and the companies that stood firm really being celebrated for that, we started to have some concern that a name change might actually deter participation more than help. And so it was really interesting to kind of see that conversation change over time. But ultimately, the feedback that we received was overwhelmingly in support of keeping the current name. The vast majority of employers we spoke with are continuing their DEI work as they were before, as this is the State Bar, and they really appreciate that the State Bar has continued to do that, both with the Leadership Seal program and with other programs. And so given that, we are not changing the name at this time, and also not substantively changing the program parameters. There may be some very minor wording changes to the application forms, but they're really actually edits in the spirit of clarifying rather than changing any of the parameters or requirements. And so in terms of next steps, we anticipate releasing application forms next month. And then those would be due back in September, mid to late September. And also want to use this kind of relaunch to spend a little time on the State Bar website and in social media posts, being really clear about what the State Bar's definition of and approach to diversity, equity, and inclusion is, saying that this is what DEI means for us, and this is what it doesn't mean potentially. And so in that work, would love to reconvene, re-engage the DEI Leadership Seal Working Group. So you all will be hearing from us quite soon. But that is the end of my slides on the Leadership Seal program. Happy to answer any questions, hear any responses or feedback. And I'll stop sharing just for the sake of being able to see everybody.
Thank you, Danielle. Any questions or comments? I don't see any hands. All right, thank you.
All right.
Then we'll move right into your next presentation.
Sure.
Which will be on our Partners in Progress Summit.
Sure, just a moment. Right. Great. And this one will be quite brief. I have one slide here. But we held our Partners in Progress Summit yesterday at the Los Angeles office. We had about 45, 50 folks there in the room besides our State Bar staff team. And the agenda for this really centered around civility. And so we had a presentation from a colleague, Rachel Brewer, in the Office of Professional Competence on proposed civility requirements for attorneys. We had a great keynote address from Professor Christine Goodman at Pepperdine on the intersections between civility and bias and what civility means in different contexts. And then a panel discussion, which was moderated by Tara Davis, and also Sarah Good sat on that panel to talk about what this looks like for various employers, how they can address incivility and bias, and facilitate a more civil work environment and experience for attorneys and folks more broadly in the legal profession. And then we had some breakout sessions for attendees to talk to each other, right? And talk about both civility and bias, but also their diversity, equity, and inclusion work a little bit more broadly, and just sort of share with each other how they're feeling and how things are going at their organizations. We also had remarks both from Leah Wilson and Judge Rhodes, and I thought it was a really lovely event. We sent out a feedback survey earlier today, so we don't have that back yet, but in kind of informally, anecdotally, feedback we received at the event was overwhelmingly positive. We had several members of COAF there, so if anybody else wants to chime in about their experiences, happy to hear that. But otherwise, I can open it up to questions.
Yeah, we had about a half a dozen current and former members of COAF, which was really great. Shalak?
I just wanted to commend Danielle for the hard work that you put into putting that together, and thank you for being really thoughtful about the topics and building on not even year to year, but summit to summit and experience to experience. And Tara, that you did an amazing job moderating your panel and eliciting feedback from Sarah and others that was really instructive, I think, and helpful for all of us there. It wasn't just like a talking heads type thing. It was really like, oh, this is stuff that I could use and be meaningful. So great work to all.
Definitely true. And I was excited. We had interns, externs from the state bar,
Yeah.
which was really great to see there and involved in the conversation. Any other questions or thoughts? No? Looking forward to next year's summit, whatever the topic might be.
Well, we do plan to have another virtual summit, so we have another touch point.
Excellent.
Before the year before the year ends. But then, yes, next year we may even try to have it in San Francisco.
I was going to say we need to engage Northern California.
Yeah.
As well.
So.
Thank you, Danielle.
Of course. Thank you.
We will go to item 4.6. Sylvia, I see, is on our screen. This is an update on the research related to artificial intelligence and bias in recruitment and advancement.
Hi, everyone. Glad to be here. My name is Sylvia Nam. I'm a senior program analyst in the Office of Access and Inclusion. Today, oh, you just hit mute. Sorry,
Sorry, I hit mute by accident. We can see your whole screen.
Oh. Haha, okay. Let me try that again. Let me try that. All right.
There we go.
Yay. Okay, great. So hi again, I'm a senior program analyst in the Office of Access and Inclusion. Today, I'll be providing a brief follow-up on the ongoing research on artificial intelligence and bias in recruitment and advancement research, which I've been doing so in collaboration with the working group comprised of Judge Rhodes and Yusuf Zakir. This update builds upon preliminary research findings that I shared with COAF back in March, the working group discussion in May, insights gathered from a first round of interviews with law schools, and proposed next steps in the research and engagement process. So as a quick recap, the broader goal of the project is to better understand how AI and related technologies are reshaping the legal profession, particularly through the lens of equity and bias. So back in March, I shared findings from my review of existing research on bias, not so much in legal employment, but employment generally. And this included how legal experts, civil rights advocates, and academics see the role of AI in reinforcing structural and systemic inequities. And I framed the work within what I think to be a broader category of automated decision-making, or ADM, which includes AI, but also encompasses other forms of rule-based or algorithmic tools used in hiring. And these tools are quite widespread. So according to Fast Company and Harvard Business School, 7 out of 10 employees use ADM tools in the hiring process. And 99% of Fortune 500 companies rely on applicant tracking systems, which often have an algorithmic set of built-ins, whether that be filtering, ranking, and screening job candidates. And so these sorts of tools automate resume screenings based on knockout questions. So for example, if you list a number of years below a threshold, or keyword matching for required qualifications, as well as predictive ranking based on past hiring data. So during the working group meeting in May, members raised 2 important areas of inquiry that followed, again, that presentation of preliminary research in March. And these questions were refined by COAF's broader mission and the range of different stakeholders that it engages with, law firms, law schools, the courts, where diversity in the legal profession and tech likely widely vary. And so first, there was a strong interest in understanding how law schools are preparing students for ADM-influenced hiring environments. And so questions were included: are career advisors discussing applicant tracking systems or algorithmic screenings when doing advising? And more generally, have advising practices evolved in response to this rapidly changing tech and AI environment? Second, members were curious about the focus areas of AI task forces in both the public and private sectors. So questions were things like, what are they prioritizing? How are they looking at bias, transparency, governance, as well as workforce implications? And where might the working group within COAF learn from these conversations? So to follow up on the questions raised by the working group, I conducted a first round of interviews with law school career services professionals. And the goal is to gather a diverse sample that include ABA accredited private and public schools, California accredited schools, as well as unaccredited schools, in order to understand how different faculty advisors, staff advisors are mentoring and engaging with students in the face of, again, a rapidly set of recruitment technologies, particularly tools that I described as ADM and AI. These interviews focused on how advisors and law schools are also responding to changes in employer practices, including structured processes like the on-campus interview, and whether or not tech-driven screening is shaping, again, their broader approaches. And these conversations are ongoing, and the hope is that they'll surface challenges and practices across different types of institutions across the state. So I wanted to share out some preliminary findings from the interviews that I've conducted so far. And one thing to note is that AI hasn't emerged as a primary concern among law school career advisors directly. However, they did point to several tech-related and structural changes that are creating real challenges, especially for underrepresented students transitioning into legal careers. So, for example, as we're all aware, in the last 5+ years, if not longer, the rise of remote and hybrid work has shifted employer expectations and reduced informal and in-person relationship building opportunities. Advisors also noted that recruiting timelines have accelerated rapidly, with some firms recruiting incredibly early in the academic year and adopting less predictable patterns, especially when it comes to the OCI, which in turn have made advising more complex and in many cases have increased or fractured information and creating information gaps for students who don't or may not have access to networks or insider knowledge. And in this shift, recruitment has shifted shifted from a relationship between law schools and law firms, more collaborative, that is, to the purview of law firms alone. So law schools have less say in the recruitment process because students are applying directly with law firms, and that fundamentally is enabled by tech. So looking ahead, I'll be conducting additional interviews with key stakeholders, and also going back to that question around AI task forces in the public and private sectors, engaging with the NALP AI task force. NALP is the main trade group for legal employers and law schools across the United States and Canada. And the hope is that the discussion will focus on how AI and other technologies are shaping the firm side, as well as broader hiring trends. And secondly, this is a recommendation from Judge Rhodes. I'll be reaching out to the Judicial Council's AI task force, and they have a number of publications that I'm reading through now currently. And they're looking at how, and to see how AI is intersecting with fairness and access within the court system, if that's a question that's come up for them. So their work may also offer useful parallels or insights for the work of COAF as we think about biasing technology and professional advancement. And the hope is to then reconvene the working group in July to review findings and discuss potential deliverables, as well as additional directions for continued research and engagement. So thanks for your time and attention. I'm happy to answer any questions you may have. And of course, if anything comes up, please feel free to reach out to me.
Thank you, Sylvia. Any questions, folks? Tristan.
Thank you for your report. I'm wondering if one of the things you might be able to ask going forward, if you didn't already and I missed it, is how many of the people who are using the AI, whether it's the law school admins or the law firm admins, have been asking questions of their provider about the data set and how they are scrubbing it for implicit bias. I don't think I need to explain that that is rampant. And I'm just wondering if any of the firms are aware of that. I think that might be helpful to start asking. Bless you.
Great. I made a note of that. Surprisingly, in my conversations with law schools, they don't encourage students to use AI at all. And career advisors have said that the vendors that they've spoken to say that there's a lot of anonymization of the data set to reduce questions around bias. But I think there's that question then also of validation and verification. You know, do you say what you say, or do you do what you do based on what you say? And is there a gap? So I'll be sure to ask. And then when I approach employers, I will be sure to ask that question. Thank you for that.
Sylvia, and please feel free to reach out to me, I think, again, if you wanted to talk about it more.
Great.
Anonymization doesn't fix the problems that we're talking about.
Any other questions or suggestions for Sylvia?
Is it possible at all in the interviews that are being conducted to also interview one of the technology companies that is facilitating some of the recruiting efforts between law schools and also future employers? One that comes to mind off bat is Flow Recruit. Yep.
Yeah.
Which now almost every law school uses.
Because we were told the law firms.
Yes, but they're great.
Yeah.
They're great at selling it.
Yeah.
So if you could get a sense of, you know, what they're doing and if these things are top of mind for them.
Can you restate the name of the company?
Flow Recruit.
Flow?
Yes,
Flow.
FLO.
Okay.
Recruit.
All one word.
Okay.
And if you wanted to, Sylvia, if you follow up with Alexis Joyce, who I'm aware you spoke with, she has a contact at Flow Recruit. That might be an easy way to get that information.
Great, thank you.
Good suggestion. Anything else? Great. Okay. Thank you so much, Sylvia.
Thank you.
We'll move then to Mara, who will give us our presentation on research related to less frequently considered forms of diversity.
Thank you so much. Let me share my screen.
All right, can you all see my slides?
Yes.
Great. Thank you again so much. My name is Mara Vibey. I'm a Senior Program Analyst in the Office of Access and Inclusion, and I'm going to be discussing our preliminary research into two of the less frequently considered forms of diversity in the legal profession. This stems from the 2025 COAF work plan, which includes identifying data-supported practices that promote retention and advancement of a diverse and inclusive legal profession, and specifically studying less frequently considered forms of diversity. The initial research that I'm going to be presenting is going to focus on people with disabilities and veterans. These are two of the different lesser considered areas of diversity that were identified by COAF. So this work is very much ongoing and in progress. And in the future, there will be presentations on other groups that are less considered areas of or forms of diversity. I'm going to be focusing on the current inclusion status in the legal profession of both people with disabilities and veterans, some of the entry barriers that these groups face, retention barriers that impact their careers, and then next steps in our process. So I want to begin with people with disabilities. This represents a significantly underrepresented group in the legal profession. The numbers tell a stark story. Only 5.7% of California attorneys report having disabilities, which contrasts starkly with the 25% of California adults. And this is according to the State Bar's 2025 Diversity Report Card. This is a more than 4-to-1 gap between the general population and the legal profession. And there are a couple possible factors that likely contribute to the disparity. One is actual underrepresentation, where fewer people with disabilities are entering or remaining in law. The other is underreporting, where attorneys do not disclose disabilities on surveys or to their employers. Nationally, the National Association for Law Placement, or NALP, found even lower numbers at 1.99% compared to 28.7% of US adults with disabilities. So this is not an issue that is unique to California by any means. And I want to pass it to Elizabeth just quick, who can talk a bit about some of the data that we've collected so far at the State Bar regarding people with disabilities.
Yeah, I just wanted to remind everyone that I believe it was last summer, we had a working group that looked at our attorney census questions related to people with disabilities. I believe it was Tara, Yemi, Jazarel, and then we reached out to Michael separately. We also engaged with disability advocates to try to figure out what was the most appropriate inclusive way of requesting this type of information. It was very interesting to find that it was split. There were some advocates who felt very strongly that we should only ask for information that is legally required. And there were others who felt we should be as expansive as possible so that people can identify themselves as they wish. And so we presented that, I believe, to the diversity liaisons from the Board of Trustees. And ultimately, I believe that the 2025 attorney census question now related to disability has two questions. One, whether you identify as somebody with a disability. And then the second question is whether your disability, and it lists some factors that I believe are ADA related, and yes or no, whether your disability includes these factors. So just wanted to remind folks of what work we have done in this area in the past.
Thank you, Elizabeth. So I want to discuss some of the barriers that we've identified that can be creating some of these disparities. And these are not by any means exhaustive lists, but there are two general categories. One would be entry barriers. And these are barriers that act as gatekeeping mechanisms to individuals attempting to enter the legal profession. These are things like inadequate or overly burdensome accommodation practices, inaccessible or, again, overly burdensome facilities and law school, courts, and legal offices, and discriminatory hiring practices, both implicit and explicit bias being present. In terms of retention barriers, these would be daily challenges that an individual may face, including inadequate technology support in workplaces or software that simply is incompatible with the systems that are being used by a legal office, like a case management system, which is incompatible with a technology being used by someone with a disability. Inflexible work schedules that don't accommodate for medical needs, open office plans that create sensory challenges, meeting formats that aren't accessible to all communication styles, and persistent implicit disability biases. These are possible barriers, and again, these are not exhaustive lists, but they do come from extensive research by the ABA, Forbes, and the NALP. A 2020 study in the Journal of Occupational Rehabilitation also revealed some concerning patterns. Female lawyers and lawyers with disabilities are most likely to request accommodations. However, these same groups have among the lowest approval rates. This pattern extends to other marginalized groups as well. So older female lawyers, racial, ethnic minorities, and LGBTQ+ attorneys. This highlights the critical need to address intersectional discrimination. The accommodation process itself can become a barrier rather than a solution in these circumstances. There's also a troubling paradox around disclosure of disabilities, and Elizabeth kind of alluded to this earlier. Data regarding implicit bias collected by the ABA revealed that 38.5% of lawyers with disabilities report experiencing subtle workplace biases. And most concerningly, disability bias has improved by only 2% over the past 14 years, compared to a 15% improvement of racial bias and a 33% of sexuality bias. I would like to caveat that does not mean that the work is done, but it does mean that diversity efforts focused on disability and inclusion are significantly lagging behind the other diversity efforts. The report of bias and the lack of improvement in implicit bias regarding disabilities can have a direct impact on a person's willingness to disclose for understandable reasons. So non-disclosure then perpetuates an invisibility and lack of support. However, disclosure itself risks discrimination and career limitations. 25% of law offices actually don't even include disability data to the NLIP. And this creates a cycle where disabilities remain invisible and unsupported. So you can understand how disability advocate groups are kind of caught between a rock and a hard place, where you can advocate for more visibility, but that visibility in itself is not necessarily a solution if we're not addressing the core biases around disability in a profession. Many attorneys with disabilities engage in something called masking, and this is hiding a disability through compensating techniques. So a disability may be more or less visible, really depending on the environment. So the impacts of this are significant. Some examples include taking longer routes to avoid requesting accessibility accommodations, memorizing layouts rather than requesting accessible formats, creating elaborate systems instead of requesting deadline flexibility or assistive technology or clear communication, basically coming up with workarounds of their own volition. And the impacts, as you can imagine, is a great amount of energy gets diverted from performance to coping mechanisms. And this can limit career advancement. A study done by the University of Chicago found that attorneys with disabilities burnt out at a rate that's nearly 10% higher than the average attorney. And this is a profession in which we are already facing burnout by attorneys, and it's something that as an entire community we are trying to address. So people with disabilities are facing this at an even higher rate. This has obviously a very negative effect on the individual, but it also deprives the profession of the full contributions of attorneys with disabilities. So it is in the legal community's best interest to figure out a way to better support people with disabilities. I want to move on to veterans in the legal professions, and unlike people with disabilities, veterans appear to be proportionally represented, but they do face distinct challenges related to cultural transition and career trajectory patterns. So 51.5% of California attorneys are veterans compared to 4% of the state veteran population. Again, this is according to the State Bar's 2025 Diversity Report Card. And this group represents a wide range of experiences in terms of what military service meant for that individual. Veterans, according to the National Association of Law Placement, which studied the 2018 class, found that they are less likely to hold bar passage jobs. They also prefer government positions over private practice compared to all graduates. And when in private practice, veterans favor smaller firms and solo practice, with only 1.75% of veterans serving as lawyers in large firms. These patterns generally suggest that veterans may face barriers in certain career paths. So although they are entering the legal profession, they are either intentionally diverting themselves or being indirectly diverted towards certain positions within the legal profession. Now, according to the U.S. government, U.S. Department of Veterans Affairs, veterans face some unique challenges. Entry barriers include the process of entering the legal profession, and these can include undervaluing military experience compared to grades and test scores, complex financial aid systems that don't always account for veterans' unique circumstances, and again, the implicit biases about veterans' ability to adapt to a civilian workplace culture. In terms of retention barriers and ongoing challenges, veterans are on average older than traditional students, so they experience ageism at a higher rate. They are also more likely to be balancing law school with family responsibilities as well as outside employment. Most veterans are first-generation college students, and they may lack established academic and/or professional networks. And they must consistently translate military skills and experience into civilian terms. These demographic differences in themselves do compound the challenges that veterans face within the legal profession. There is significant overlap between veteran and disability status that create additional compounding challenges. So 67.9% of student veterans have a VA disability rating, and this would be a disability that was acquired during military service. Of those with disabilities, 73.2% report some or severe impacts on academics, and 67%, so 2/3, report some to severe impacts on employment. These create intersectional challenges. So veterans must navigate both the military to civilian cultural transition and the disability accommodation needs, which means that they face the barriers that we've discussed for both groups simultaneously. Unfortunately, we lack the specific data on the proportion of overlap because the data we have available focuses on students primarily for veterans. And we do have more data on veterans within the legal profession, but there's not a direct overlap yet between the veterans and the individuals with disabilities and the barriers that they are facing. But that is something we are looking into more closely. So I'd like to now shift, if I may, to open this up for some discussion and to gather your insights. And I have a couple key questions. One, I wanted to ask the group if there are additional barriers or challenges that you've observed or experienced regarding inclusion of people with disability and/or veterans in the legal professions, which might be helpful to also consider in our research. And these can be either entry barriers or retention barriers, but I wanted to solicit your thoughts on that.
We'll start there. Thank you, Mara, for that helpful presentation. Any thoughts, Tristan?
Well, as a disabled person myself, I experienced some of this when I took the bar. When I started my first job, I mean, the bar was very helpful, but the process is still, even just here going to the bathroom, the handicap stall is the last one, which means I have to walk further than everyone else. And you know what I mean? Like this, it's constant, right? Every day, all day long. I actually had to leave a job because of some a kerfuffle around the accommodations I requested. And those accommodations had to do with hours, had to do with needing flexibility to come in later in the morning because of chronic pain. And it wasn't received well, right? So, and that was as a fairly senior attorney who was well valued by the organization. I can imagine how hard it would be for somebody who's on the newer end of their spectrum. That said, just to share my experience, like you invited, I don't have any particular suggestions for going further, but I do want to suggest that I think a lot of people misconstrue the difficulty that folks who, for example, use the assistance of a wheelchair face. By far the most doors that I go through are not wheelchair accessible. And by that, I don't mean they're not wide. I mean, to pull the door open is incredibly difficult. And, or even like for somebody like my mom, who is also disabled, she's not strong enough to open most doors. And, you know, we've got bad ramps, and like even just today, I didn't want to use the lift thing outside the state bar just because I thought, well, that's going to take too long, right? So there's, but if I was in a chair, of course I would have used it. And so I think that the thing to remember is, unlike perhaps at least sexual orientation, gender identity discrimination, I think that disability challenges are constant. Like every time, you know, you get in and out of a doorway, every time you are, you know, trying to use the restroom, every time you know, need to sit at a meeting, and you know, like if you use the assistance of like a dragon naturally reading, for example, you can't sit in a meeting and have it read to you like everyone else did without having headphones in. And I just think there's so many challenges. I'm really glad that we're looking into this. And you know, the number of buildings that I've been to that were not accessible is mind-blowing, really, today. I mean, at least we're way better than Europe, but yeah, I'm really glad that we're working on this.
I see, let me start with Kamal, and then I'll go to Alana, and then back to the room.
Thank
Kamal?
you. So one observation, I found the numbers to be really low in terms of people who reported having a disability on the State Bar's diversity report card. So I worked with a diversity survey vendor before in the past who had benchmarks for not California, but the legal profession. And their data actually kind of matched up with the percentage of people reporting disabilities in the general population. So I thought that was interesting. And I think it might just be that they had, you know, they hadn't surveyed all that many people because they relied on their customer data to get their benchmarks. But the two retention barriers that I've observed are there's significantly less peer support for attorneys with disabilities. And a lot of that, I think, relates to what you said in your presentation, where people are reluctant to disclose. So things like employee resource groups or affinity groups can be really challenging to start up in a legal office. So I think that's something that likely contributes to retention issues. And then the other thing that, at least just in my personal observations, doing diversity surveys, something I noticed is that a lot of the disabilities that people reported were mental health related. So it really dovetails with things like work culture and workloads. So I think that reluctance to change work culture can be a retention issue as well when you're talking about disability. And so I feel like we have to be careful about not talking about disability in a silo that doesn't account for some of the things that we know about the legal profession, including, you know, higher suicide rates, higher rates of substance abuse, things that all relate to mental health.
Just add on to one thing that Kamal mentioned about retention for both disability and for veterans is the lack of bar associations to the same extent. I know that Sacramento just launched the Disability Inclusivity Bar Association, which I think is the first in the state, but I might be wrong about that. And I don't know about veterans bar associations, but there's definitely not the same level of programming as with other groups. Alana.
Okay, there we go. Thank you. First, just thank you for doing this work. It's the information you presented was very impressive, especially I believe it was the 2020 study you referenced that also highlighted the intersectionality with these. One of the barriers that I see, particularly I will focus on veterans, although my husband is not an attorney, he is a veteran, and I think that there are just some things that are universal, and it is a lack of education on employers. So it's always up to the veteran to translate the skill set that they have. And so there's just a lack of educational resources to raise awareness of some of the challenges and addressing the stereotypes. A lot of times when you do have implicit bias training, again, these are less considered in that. And so whereas people may be familiar with racial stereotyping of African Americans, Asians, Latinos, there's less stereotypes about veterans. What I will also say about disability is kind of the same, a lack of awareness. We haven't really had applicants that I'm aware of in all of the capacities where I've had something to do with the hiring of the entity I was a part of. But having been in management, when people have to go out on disability leave, or sometimes they have an accommodation, has been very eye-opening as to resistance. It's just like it's a culture of, now you're getting special treatment. How can we do that? And I was actually appalled. I think someone had injured. It was actually a work-related injury, so they were not able to use their keyboard. And I think the request was to, I don't know if it was something like Google or like Google Speak, or it really wasn't an accommodation, because basically what you have to do is select the text and then click on read. And it's like, well, they're using their wrist and their arm. And so it's beyond just, the attorneys who are, we're legally trained in probably the substantive area, but not necessarily in the sort of human resource administration. And again, there are other just sort of accommodations, and these are in the realm of maybe a temporary accommodation, but for those who would need it all the time, I think it's just a lack of education. And then the approach is, well, let's just create this temporary, fix, like not looking at the doors until it is an issue, but not considering it on the front end. And then when I just look around in my practice, the individuals, I know not all disabilities are visible, but just in the workspace, it's less visibility. And that just, I think, lends itself to the lack of awareness and empathy on some levels. I think there is an empathy issue. It's an understanding issue, but it's also an empathy issue as well. So I just have noticed that those are two barriers. And then I think also, and maybe this came in your focus group that you had, but I think for some individuals, all of the identities can be overwhelming. So, that's just something else to consider is this going to be, instead of me being identified as a hardworking, competent attorney, now I have all of these other labels, and it's preventing people from seeing what I really want them to see. Thank you.
Thank you. Thank you, Alana. Shalak.
Okay. I think that something to focus on, this is both entry and retention, is that there has been, in my observation, a resurgence of stigmatization around people, particularly attorneys with disabilities. And I'm going to highlight in particular the non-visible, so mental health, ADHD, etc. I'm troubled by what I am seeing among pre-law and law students. That reveals, to Alana's point, a lack of empathy and understanding. I have observed and heard directly from students both at my and a range of institutions, and from administrators at, again, a range of institutions, the concerns that students are perceiving, and some faculty are perceiving, a rise in student accommodations as a signal of people cheating the system by saying there aren't that many people with disabilities out in the general public, therefore, how come all of these people suddenly need them? And that has led to sort of two-tier, right? A concern about what people have been calling legitimate disabilities. So the concerns about, and I think it's even come out in our conversation, well, what about the doors? What about seeing? What about sort of physical disabilities where everyone goes, oh, of course you need to do something about that. But the things that people might attribute to, well, just work hard and you can overcome it. You don't focus as well. That's because you're trying not to. You're not trying hard enough and you want someone to give you something. So I think that one of the real barriers perhaps that you can look into, Mara, to turn this rather from venting into something positive is stigmatization. Perhaps there are industries where there has been less stigmatization around even more invisible disabilities and the ways that that can translate in the legal community, and the ways that I'm even tying this to our earlier conversation about the PLLs, right? Like that sense of being less of an attorney if you received an accommodation. Well, are you really the top of the class if you got an accommodation? Did you really deserve that LSAT score if you got an accommodation? Should they really be at such and such firm if they got an accommodation? All real questions that I've heard, or commentary that I've heard, by the way, again, from a range of institutions. So that, I think, becomes an entry barrier. And then where I've heard it in concern from attorneys and employers is, well, someone gets extra time on their exam, they don't get extra time to do the thing for the court, right? And I'm like, well, they kind of do. They just stay up all night. I've written briefs. Sometimes you just stay up all night. You may or may not bill the client for all that time, right? Depending on the type of practice you're in. But I think that becomes a retention barrier, and certainly that siloing that happens is if you now think if you are one of those people who received the accommodation, say on the bar exam, and you're hearing these conversations about younger attorneys, are you going to self-disclose? Well, I actually had to receive that, and what does that mean? And do you want to Alana's point, be identified as anything other than smart or hardworking if you hear that people think that people who need mental health or brain neurological accommodations have worked less or don't care as much or are trying to cheat the system? So don't know what you can pull out of that, Mara. Maybe this is just a space where I was trying to share it. But I think looking into stigmatization and the resurgence of stigmatization among younger attorneys is very concerning for me, when you would think we were going in the opposite direction. I don't know if the medical field, which I might think of as most similar in terms of a profession where people think that there needs to be a certain amount of like work and so on put into sort of the licensing process, if there's anything there that might be worth looking into for adaptation around acceptance and inclusion.
Thank you, Shalak. Yeah, Tara.
So I have been very concerned on the retention piece around those who will be successful long-term in their careers by the lack of accommodations that are being given to them. And I don't know if it is a result of, I agree on the stigmatization piece and then the lack of education. And speaking on the lack of education around how do you handle the accommodation requests? And then how do you prepare ahead of time for the accommodation requests? I don't know that anyone is adequately proactively preparing for the accommodation requests. And I know I certainly don't feel like that is something that I have even had the tools to be able to do successfully. And so if anything comes of this research and working group, I would like to see, what do we do around accommodations? What accommodations are, I think sometimes people are thinking about how much money and the resources it's going to take to make the accommodations possible. And I think we're starting to already see an increase in those who are neurodivergent coming into the workplace. And when I think about it, I think about those who have ADHD, the timeline that we're setting is not necessarily a reasonable or feasible timeline for them. And so if there is any way to look into accommodations with the research and recommendations for employers and institutions around this area, I would greatly appreciate that personally.
Thank you, Tara. Oh, sorry, Tristan.
No, that's okay. I just, as far as barriers to entry or retention, I think maybe an education campaign might be helpful, because what I experience when I'm in, my giant knee brace, or when I was walking around with my seeing cane, is people don't know how to react to someone who is disabled or has a disability, regardless of what kind. And so they feel uncomfortable. And then there's sort of a shame there, right? Like people, and I've spent significant time in a wheelchair, people either stare at you nonstop or they won't look at you, right? There's just not a good understanding that our folks who have the assistance of something, or, have depression, and that are regular folks, just like everyone else. And so that plays into the stigmatism. There was also something that was a former employer did that can maybe be part of the practices for positive impact. And that was, they had a veterans liaison. So there was somebody in the office who was responsible for when a veteran would come in, they would talk to them, they would make sure they had resources. They went to recruitment fairs for veterans. They did that work. It wasn't a whole group, but it was a person. And I think that was, at least the employer where they did this, we had higher than average percentage of veterans. And so I think that could make a big difference. Same thing with disability. I mean, the people don't want to disclose because they are afraid, appropriately, that they will not get hired, right? Just like if you're pregnant, you don't want to tell your boss, oh, sorry, I'm going to be leaving in 9 months. Oh, well, right? So I had a mentee of mine who had a seeing eye dog, and a support dog for other reasons. And she didn't bring the dog to the interview, never brought a dog to an interview, because people, we don't have dogs here. And so this bias that, like my wife right now, she has a need for a support dog. And at her company where she's working, which is in a university, it's a vet school. And so they said, well, you can't bring your dog because then all the rest of our students will want to bring their dog. It's not, Qualcomm creating a policy, right? Like people don't understand the distinction between the two. And this idea that, it's not a real request, I mean, that is just appalling to me. And it kind of gets right to the core of the things that I worry about, right? Like I hardly ever tell anybody that I had accommodations for the bar, because I don't want them to be like, well, that's why you passed on the first time, right? Like this whole bit. And so I just think that this is a really important area for us to be looking into. I'm sorry I don't have more ideas, but I did think of that one. And it does occur to me that in all the companies I've worked for, there's never been an employee resource group dedicated to disabilities. And I worked for big government and big business, and we never had it. And so you also have a lack of mentors, right? Because you feel like if you're a person who has severe depression, that you might need to have a mentor who also has that, right? Like there's just so many different challenges, just like everything else. You need people who understand in order to help you figure out how to navigate that.
I have one suggestion, and I can always, Mara, if you follow up with me, I can get you exact contact information, but the National Association of Law Student Affairs Professionals, NALSAP, has a subgroup that focuses specifically on disability and accommodations. And there are several within that subgroup who have been, one might have even authored that study that you referenced, but we've been within that group a lot of work around disability accommodations, the ways those play out in law schools, comparing those to bar exams. And so there may be some space there for you to speak with some people in that around entry barriers. And I think there may be, I don't think there's a formally analogous group within NALP, but there may be within that, and people who are more focused on it in NALSAP, they may know the individuals at NALP that are doing similar work at the law firm level. So if you follow up with me, I'll get you the right contact people in NALSAP. To Jennifer Espinoza comes to mind, but I'll get you the right contact people. Yeah.
Great. Anybody else? Okay, Mara, I hope we gave you enough.
I really appreciate all the thoughtful feedback, truly. We have no illusions that we're doing this research and we're going to solve the problem overnight, but we really hope to make some inroads. So thank you very much for the feedback. And I think it's a good time to move on to next steps and announce that we are soliciting volunteers for our working group. And we will be conducting additional research in this area. And then obviously you will also be hearing from us about other areas that COAF identified that are lesser considered areas of diversity within the legal profession. Elizabeth, is the best thing to do to have people email me as volunteers for the working group? How would you like to organize this?
I mean, if people are interested, you can let
Anybody
us know.
Okay, or we could just raise hands. Yes.
Or yeah, you can email me or Mara afterwards. Kamal has raised her hand.
Okay.
The other thing I want to note is that the working group is for like the research for all of the areas that we'll be researching. Mara's just presented the first two that we've worked on. So it won't just be on these two topics. And you can reach out after the meeting.
I'm interested. Maybe Kamal and I could trade places.
Oh, for the other working group. Okay. Great.
Thank you very much.
Elizabeth will reach out and confirm
Yeah,
all those different working group assignments. Perfect. Thank you so much, Mara. Okay, we'll go to 4.8, which is a discussion of additional diversity, equity, and inclusion initiatives. We don't have any to discuss at this point, so I'm going to move to the COAF work plan. Elizabeth, anything on the work plan?
It is just attached to our agenda for reference, and as I mentioned this morning, it hasn't been approved yet by the board, but will be, I understand, at our next meeting. And we're moving forward, so.
Okay, thank you. So now we'll move to our liaison reports, our remaining liaison report. Alana, thank you for being here for the first time. And thank you. Unfortunately, you're learning that we leave our liaison reports to the end, usually. So you'll have our final report for the day. Go ahead.
Well, I wasn't notified that I would have to give a report. I
Oh.
didn't see it, so I thought I had a report. So I guess I would just say I'm Alana and I'm new. And I will be prepared to offer a report, but I didn't have anything. But it would be great if anyone can share with me previously what was reported out.
Sure, Alana, I can follow up with you. It's Elizabeth, so I'll follow up with you.
Okay.
Thank you for being here and for diving in with both feet today. We appreciate your suggestions, your thoughts on all of this, and we look forward to having you at future meetings. It's been a while since we've had a consistent CLA representative, so thank you for volunteering and for showing up.
I did have just one comment. I'm not sure if COAF was had any input on this, but I attended the series that the State Bar presented on strategies for attorneys that have ADHD. And that was excellent. And I have never been diagnosed as ADHD, but I supervise individuals who I think may have been, but even if they have not, I found it to be just excellent. And so I don't know if that's a product of your efforts, but it was excellent. So I just wanted to say I enjoyed that. And that's one of the things that motivated me to actually want to be more active.
That's great to hear. I know our State Bar staff really appreciate hearing that too.
Yeah.
Okay, I think we do not have Gladys Valentine, who is our Cal Law liaison here, and Judge Diaz gave her report previously. So that brings us to the end of our agenda. Thank you, everybody, for all of your thoughts, your input, your participation. We appreciate it. Good to see you, and we'll reconvene on September the 5th for our next meeting. That one will be virtual, and we look forward to seeing you all then. Take good care.
Thank you.
Bye.
I don't know why I was about to applaud.